analysis. I did it yesterday as we talked, but there was a good faith disagreement between me and the Court of Appeals, which gets to decide as to what the language meant and whether or not Congress actually intended to exclude the APA using that language under those circumstances.
Thank you very much.
Senator Leahy.
Thank you, Chair. And welcome back, Judge Jackson. I know yesterday was a grueling day of questions. I commend you for your poise, your endurance, your thoughtful answers. I felt privileged to be here for hours of that, and you had even more hours. But I want you to know the reaction in my own state of Vermont. I've gotten all kinds of emails and calls and from friends across the political spectrum. They're all been praising you. And they said they realized that a lot of the questions that were lobbed at you had nothing at all to do with your qualities as being on the Supreme Court, but were some members, unfortunately, aiming for what a soundbite that they may be able to put on a political website where it now is. For example, we heard some overheated claims yesterday that your representation on Guantanamo detainees somehow signaled your policy preference with how the United States has dealt with those detainees. Every single member of this committee, especially those of us who have been assigned as counsel in cases, should know better than to conflate a nominee's past representation with their policy positions, or to argue that a nominee espoused their client's viewpoint simply by choosing to represent them. So your policy views aside, can you reiterate why it's so important for our courts to have the benefit of the best possible legal representation on both sides of any case, and especially in cases where we are in uncharted legal and constitutional waters?
Yes, thank you, Senator. So I've been a judge for almost a decade, and what I've learned is that as part of my duty to render decisions consistent with my judicial oath in support of our Constitution and the rule of law, I need to consider all of the arguments related to the dispute that is being brought in my courtroom. I need to hear from not only the parties who are prosecuting a case, for example, a crime, but also from the defense. And some of these crimes are terrible crimes. Our Constitution is designed to ensure that the government affords due process to people who are being accused of crimes. And one might think it's even more important in a way in a case in which someone is so reviled. It's kind of like the First Amendment. It's a protection for unpopular views. It's needed when there's a chance that the government will suppress or do something that's untoward. And so in the criminal justice system, we have many, many amendments that are designed to make sure that unpopular people who are accused of doing terrible things, are still treated fairly by the government. And that's a limitation on government power, which is the framework of our Constitution. It is about limiting government overreach. And so in the criminal justice system, you can imagine, and the framers imagined, a world in which the government would use its authority to deprive people of their liberty, to throw people in jail, to lock them up and throw away the key, to not give people the opportunity to make arguments about their freedom. That would be a real exercise of government power, government overreach. And so the framers said, what we're going to do is we are going to put in our foundational documents a protection for people that the government is accusing of crime. And that's not to say that the people are innocent. That's not to say that they haven't done terrible things. What it's about is ensuring that the government does what is required in order to ensure all of our liberty. It protects all of us because there might be someone who is innocent, and if the government is able to just do whatever it wants in criminal process, we are all at risk.
Well, and I think we've all seen cases where that happened. I mentioned to you yesterday that I spent nearly a decade as a prosecutor, and especially when I had serious cases, I wanted the best defense attorney possible on the other side. I wanted a case that if I won, it usually went up on appeal automatically if it carried a heavy penalty. I wanted the court, the appellate court, to look at it and say, okay, there were not errors of counsel on either side. But I also, as a strong proponent of our Constitution, I think what you're saying is something I totally agree with. We have to have the individual's rights protected. It doesn't mean the defense counsel is in favor of murder or rape or armed robbery, but the rights have to be protected. And let me tell you about another area. I've authored and I've long championed the bipartisan John Lewis Voting Rights Advancement Act. I think it would help curtail the growing wave of voter suppression sweeping across our country. Again, something we don't have to worry about in Vermont, but unfortunately do in other states. I'm passionate about this legislation. I've always believed that our democracy is stronger when we expand, not shrink, the ranks of our citizens who have fully participated. I believe our democracy goes stronger with your historic nomination and your presence before us today. And I've told you privately how my family members feel about that. Why is it important for our democracy's institutions, courts and all others, to reflect the rich diversity of our nation's citizenry?
Thank you, Senator. One of the things we've been talking about is the difference between the judicial branch and the other branches of government. We have three branches in our federal system, and the legislative branch has certain powers, and it can do certain things to ensure that its prerogatives are achieved. And the executive branch has the power of might. The president controls the military. The judicial branch, its force in our system is the protection of the rule of law, which can only be done by essentially the consent of the governed. It can only be done if people in our society believe, decide, and agree that they're going to follow what it is that courts decide. And so one of the reasons why having a diverse judicial branch is important is because it lends and bolsters public confidence in our system. We have a diverse society in the United States. There are people from all over who come to this great nation and make their lives. And when people see that the judicial branch is comprised of a variety of people who have taken the oath to protect the Constitution and who are doing their best to interpret the laws consistent with that oath, it lends confidence that the rulings that the judge that the court is handing down are fair and just, that everything has been considered, that no one is being excluded because of a characteristic like race or gender or anything else. And that's important. I would also say that that it's important from the standpoint of role modeling, that I have been so touched by the numbers of people who've reached out to me in this period of time to say how much it has meant to their daughters, to their sons, to the next generation, that I've been appointed, to nominated and hopefully confirmed.
Well, I agree with you. I've certainly seen that within my own family. You know, we do have areas where we agree on things on this committee. Senators Grassley and Senator Cornyn, myself and others believe in transparency as part of our democracy. We've done this with the Freedom of Information Act when we've updated it a number of years. Senator Cornyn and I have been the key sponsors of legislation, joined by Senator Grassley and Senator Durbin and others, to improve the Freedom of Information Act. You've talked about the detailed opinions you've written to try to do the same thing. I think it's safe to say you believe transparency is central to the duties of a judge. Do you intend to carry that attitude and you will become a member of the U.S. Supreme Court?
Thank you, Senator. The value of public confidence, which I was just discussing, I think is enhanced when the public understands the reasons that a judge renders his or her ruling. One of my mentors used to say, people think the judicial branch is so secretive, but in fact, the judicial branch is the only branch that actually has to tell everyone, that actually has to write their opinions and explain why it is that they did what they did. And so I've tried in the nearly 10 years that I've been on the bench to make my rulings transparent, to explain all of the inputs that I have considered with respect to the case, to lay out the law as I see it in interpreting what Congress, for example, has done in with respect to a particular case, and what legal provisions that I think are relevant to the dispute, and then to explain my analysis. Why am I granting this motion or denying this claim? And my hope is that it will help people to be confident in my reasoning, and even if they disagree with it, they will understand what it is that I think, and I think that's important for public confidence in promoting the rule of law.
Well, you know, you had talked about your clerking for justice prior, how it opened up doors of opportunity. I remember so well our conversation in my office, in the President Pro Tem's office, talking before these hearings began. You told me what you thought it meant to your parents and your family, your husband, your daughters, your parents who have been here throughout this, and what it would have meant to your grandparents. You said you were the lucky first inheritor of Dr. King's civil rights legacy. I keep a daily journal. I wrote that down. It means a lot. So let me do this sort of an open-ended question. You patiently answered our questions this week. I told you the reaction in Vermont was disappointment in some that were obviously political. I heard that from both Republicans and Democrats because they think it should be your legal thoughts in the Supreme Court. So I'd like to give you an opportunity to speak directly to the American people, including our little state of Vermont. Is there anything you want to convey to them about what kind of Supreme Court justice you would be if and when you're confirmed? It's all yours, Your Honor.
Thank you, Senator. Well, first, let me just address my comments to you in your office, which is something that I've said in speeches because it speaks to who I am and what I value. My parents grew up in Florida under lawful segregation. And what that means is that when they were coming through middle school and high school, they were not allowed to go to school with white students. This is in the era before and right after the Brown versus the Board decision. There was lawful segregation in places in this country. And it was after that time that Dr. King made his famous comments that people mention about having a dream where people can be judged by not by the color of their skin, but by the content of their character. And I then was born in 1970, and the contrast between my reality growing up in Florida and my parents' reality growing up in Florida, like night and day in terms of the opportunities that were available to me that weren't available to Judge Motley, who is one of my role models in the law. And so what my being here, I think, is about at some level is about the progress that we've made in this country in a very short period of time, I would say. It seems like a long time, but one generation, we've gone from the reality of my parents' upbringing to the reality of mine. And I do consider myself, having been born in 1970, to be the first generation to benefit from the civil rights movement, from the legacy of all of the work of so many people that went into changing the laws in this country so that people like me could have an opportunity to be sitting here before you today. What I would hope to bring to the Supreme Court is very similar to what 115 other justices have brought, which is their life experiences, their perspectives. And mine include being a trial judge, being an appellate judge, being a public defender, being a member of the Sentencing Commission, in addition to my being a Black woman, lucky inheritor of the civil rights dream. And in my capacity as a justice, I would do what I've done for the past decade, which is to rule from a position of neutrality, to look carefully at the facts and the circumstances of every case without any agendas, without any attempt to push the law in one direction or the other, to look only at the facts and the circumstances, interpreting the law consistent with the Constitution and precedents, and to render rulings that I believe and that I hope that people would have confidence in.
Thank you. And Chair Durbin, I've had the opportunity to be here The first justice I got to vote on was John Paul Stevens, nominated by President Gerald Ford. Proud to vote for him. And it's a long arc, Judge Jackson, but I am so proud of your answers, and I appreciate you yield back.
Thank you, Senator Leahy. Let's take a break for about 15 minutes.
Thank you.
Thank you very much, Judge.
All right, we've just been watching day 3 of the Supreme Court confirmation hearings for Judge Ketanji Brown Jackson. They're taking a quick 15-minute break right now, but a lot of territory covered so far. We ended the first portion of the questioning with the last 2 senators being able to ask their questions, and now they've entered the second round of questioning. So far, we've heard Judge Jackson's judicial philosophy come up once again, as well as some of her record and sentencing, and some more on her family history. Let's bring in senior Washington reporter Devin Dwyer live in the committee room, along with politics reporter Brittany Shepard and ABC News Supreme Court contributor Kate Shaw, who's here with me in studio. Kate, I want to start with you. What's your take on how things are going today compared to yesterday?
I think that Judge Jackson had a really strong start, and I think that's in part because the junior senator from Georgia, John Ossoff, the youngest member of the youngest member of the Senate who's before the committee, you know, and this is his first Supreme Court confirmation, I think was extremely effective in, you know, a couple of ways. One, he gave Judge Jackson the opportunity to talk about her brother, which was very powerful, but she took that opportunity. She talked about her family. Her brother went to Howard, was a police officer, enlisted in the military after 9/11. And she used that story to talk about both his experience as a police officer and her experience as a public defender, his experience in the military and her experience defending detainees at Guantanamo as actually 2 sides of the same coin, as not in fundamental tension, that all of this is about America, our democracy, our Constitution, and its values. And there's not really any tension between the path she took and the path that her brother took. And I thought that was just such a powerful, both personal kind of story and also story about her vision of the country and the Constitution.
And Devin, there was some commotion, you can call it, at the start of the hearing this morning, with Republican senators taking issue with what they called editorializing by Chairman Dick Durbin and how he's using his extra time as chairman. Can you tell us a little bit more about what that was about?
Yeah, there are always some political fireworks between the parties, and you saw Judge Jackson sort of sit there quietly. It didn't involve her, but Republicans sort of raising the red flag, saying that each time one of their senators had finished questioning Judge Jackson, Chairman Durbin, as is his prerogative as the chairman of the committee, sort of piped in on his own and offered some sort of impromptu rebuttals. We heard complaints from Republicans saying that's really not fair. That's not how it works. You don't get all this extra time to rebut each and every one of us. So he committed to sort of giving back some of his time of questioning, which he did. He only won about 7 minutes of his 20 minutes. But those sorts of fireworks on the fringes of this hearing are common. We saw some late last night as well. But for the most part, as Kate alluded to, a really strong start today for Ketanji Brown Jackson. I dare even say, Diane, sort of night and day in terms of her demeanor, her charisma. Today, her ease. She seemed much more confident and relaxed today, animated, using her hands in answering these questions. Even saw her flash a smile a few times. She told the committee she didn't get a lot of sleep last night, but it does seem like she's much more comfortable now. And one of her 2 daughters is back here today after neither of them were here yesterday. One of them is back sitting right behind her. So clearly on her way now, about 6-7 hours from wrapping up what could be her final appearance before this committee.
And Brittany, as Kate mentioned, Democratic Senator John Ossoff had asked Judge Jackson about her family's role in law enforcement. And she not only talked about her brother's role in the military, but also the fact that he became a Baltimore police officer and how that impacted the family, and sort of seemed to not contrast that, but show that as a complement to her work as a public defender, for example, and her work defending criminals in the courts. What did you think of that exchange, and why do you think that's a point that Democrats are trying to focus on?
Well, Diane, Republicans have been adamant to paint Ketanji Brown Jackson as soft on crime. We saw a little bit today, and we saw a lot of it yesterday. So in this attempt to contextualize her family, it's a bit of a bolster to those attacks to show that, look, just because I am black and come from a historically black university and have family members who are police officers, that doesn't mean that I am in conflict with wanting to protect the greater good. I mean, it's something that we see play on the national stage all the time with the attacks about critical race theory and about defunding the police. And I think we saw something really measured from Judge Jackson, trying to make the appeal that she is someone who both understands the front lines as a public defender, but also someone who's a family of a law enforcement agent, something that Republicans have been shy to bring up and Democrats have been eager to get in front of Republicans, especially those vulnerable Republicans who might be leaning maybe yes, no on the vote for her larger next week.
She was also asked about the limits of presidential power, which she then expanded into a larger answer about the separation of powers in general. Let's take a listen to that.
You, in opinion that has been widely cited, made the observation that presidents are not kings. What does that mean, and what are some of the most important bulwarks in our constitutional system against the abuse of executive power, against tyranny?
Our constitutional scheme, the design of our government, is erected to prevent tyranny. The framers decided, after experiencing monarchy, tyranny, and the like, that they were going to create a government that would split the powers of a monarch in several different ways. The separation of powers is crucial to liberty. It is what our country is founded on, and it's important, as consistent with my judicial methodology, for each branch to operate within their own sphere. That means for me that judges can't make law. Judges shouldn't be policymakers. That's a part of our constitutional design, and it prevents our government from being too powerful and encroaching on individual liberty.
So, Kate, we're hearing Jackson again here stressing that there are spheres and lanes within which judges and courts have to stay, that there are limits on the power of the courts and judges. Why is that a point that she continues to hammer home? And could that kind of give any clues to her thinking when it pertains to any cases that are coming before the court?
Yeah, so Judge Jackson has returned again and again to this theme that judges have a limited role in our constitutional scheme. And of course, that's right. And it's also, I think, a very effective rejoinder to any accusations of judicial activism. She said, no, judges have by design limitations the Constitution places on them. And yet, though judges are limited, they're not supposed to be making policy. When they are within their spheres, when they're deciding what the Constitution means or what it allows, judges have a tremendous amount of power. And I think that in cases like the McGahn case, which Senator Ossoff referenced, Judge Jackson has shown that she is perfectly willing to hold that other government actors have exceeded their power if they have violated the Constitution or their constraints the Constitution places on them. So in that case, Don McGahn argued that as the president's former lawyer, he couldn't be compelled to testify. He was absolutely immune. And that's the opinion in which she wrote, no, presidents are not kings and their staff members work for we the people. And so, I think that while she very much is taking the position that judges have limited power, they absolutely have very significant authority when they're acting within their lanes. And I think if there are cases that come before her on the Supreme Court involving things like assertions of absolute presidential power or immunity, she would be perfectly willing to find that those claims are not supported by the Constitution.
Do you see any cases where that might come up?
You know, there are cases kind of arising in different ways out of the January 6th events. There's civil litigation against President Trump by a number of individuals, family members of Capitol Police officers and members of Congress, essentially alleging incitement of violence. some of those cases survived a motion to dismiss in the district court in D.C. Against, absolute immunity claims by former President Trump. So I don't know if any of those cases could come to the Supreme Court, but certainly there's a chance that they could. So these questions are not abstract. They very much could be before the court, and other January 6th related cases involving the committee potentially could also come to the court. So she could be deciding these cases, and I think, she would view the role of the court as limited, but certainly sometimes in that limited role, the court has to answer the most important constitutional questions that we face.
Right. It seems like she also, in a way, was trying to make clear, yes, presidential powers are limited, so are all the other branches of government. And meanwhile, Justice Clarence Thomas is still in the hospital recovering from an infection. Devin, what's the latest on his condition?
Yeah, surprising, Diane. Now 5 nights in the hospital. He was admitted, remember, Friday evening for what the Supreme Court told us late Sunday was an infection that's being treated with antibiotics. We've been told he's resting comfortably. His symptoms are abating, but now 5 days in the hospital. That's a lengthy hospital stay for anybody right now. We've been told it's not COVID related, but no further explanation has been given as to what his condition is at this hour, why he's being held there, when he's expected to be released. So we continue to monitor that development. Remember, Clarence Thomas is the oldest conservative justice on the Supreme Court, 73 years old. He, is an icon in conservative circles. No indication that, he's in imminent harm, if you will. We were told he was expected to be released in just a few days, but people are watching very, very closely, given what it could mean if he is, in any way facing a more serious illness, Diane.
And Senator Tom Tillis asked Judge Jackson about defendants that she sentenced who later became reoffenders. Let's listen to that exchange.
If I take a look at your responses to some of my colleagues' questions and your statements to some of the defendants, it seems as though you're a very kind person and that there's at least a level of empathy that enters into your treatment of a defendant that some could view as a maybe beyond what some of us would be comfortable with respect to administering justice.
Thank you for letting me clarify. The statements that I made about my practices as a trial judge, which I'm no longer a trial judge, but were intended to explain how trial judges operate and how they impose sentences within the framework that Congress has provided. The statute that applies to us tells us to look at all of the various factors that Congress has set forward, including the nature and circumstances of the offense. Congress also tells us that one of the purposes of punishment is rehabilitation. My attempts to communicate directly with defendants is about public safety, because most of the people who are incarcerated via the federal system and even via the state system will come out, will be a part of our communities again. And so it is to our entire benefit, as Congress has recognized, to ensure that people who come out stop committing crimes.
Now, Jackson, in that exchange, also said that a key part of her process is to explain to the defendant why their crime is a serious one, because she said, as her experience as a defender, that many times these criminals were actually bitter and didn't understand why, for example, a drug offense was a serious one. Tillis then responded that virtually half of those people she gave that speech to were back in prison within 8 years. So, Brittany, what did you make of this exchange?
Well, Diane, it definitely seemed like a way for Tillis to try to figure out whether or not that he was a soft no or a hard yes on her nomination. I think that it was I think that Ketanji Brown Jackson handled it as interesting as she could. I never really have heard empathy weaponized in the halls of Congress, but I guess there's a first time for everything. And it was not just her pitch to the members of the committee, but also to the American public who are watching, who are wondering, and who are scared about rising crime rates around the country if a certain case was presented to her and the other members of the Supreme Court, if she is, in fact, made a historic member if they should be worried about what would happen in their local municipalities. And I think that she did a good job of walking Tom Tillis and the other members of the committee through exactly her reasoning of why it's important to be empathetic, especially as the criminal justice laws in this country change by Congress's own hands, and is becoming more and more sympathetic towards first-time nonviolent offenders.
And Devin, Ranking Member Grassley asked whether nationwide injunctions were constitutional. Judge Jackson kind of danced around that. She explained that invalidating a rule that an agency has enacted is not necessarily a nationwide injunction. Can you put that into context for us?
Well, conservatives and conservative members of the current Supreme Court have lashed out at these district court judges, that's the lowest level of federal judge in this country, sort of issuing pronouncements that affect the whole country from their decisions. And that's sort of what he was driving at, is trying to get Judge Jackson to go on the record taking a position on these injunctions. She explained, though, sometimes when these policies affect the entire country, if it is deemed, unconstitutional, or if there's a reason to put a hold on something based on how it's, how it was passed and implemented under the Administrative Procedures Act. That's just kind of the way it is, was essentially her answer. But certainly that's a flashpoint for conservatives, much in the same way that the word empathy, by the way, is a flashpoint with conservatives. Tom Tillis going at her with that word sort of very diplomatically. He didn't have the bite that some of the Republicans did yesterday, but that, as Brittany was alluding to, is very much a buzzword in conservative circles right now. Judges, they say, shouldn't be bringing empathy to the bench to their decisions. She pushed back, saying that it's a smart way to treat defendants, humane way to treat defendants. It's been one of her hallmarks. I've heard from her clerks that she very much believes in making sure people who come before her as a judge understand why they're there, why she's ruling the way she's ruling, what it means for them, even if they've done horrible crimes. And I think that's what she was driving at in that opinion. But we're about to see, Diane, whether or not Republicans will really keep up the firepower that they brought against her yesterday. Lindsey Graham is up next, and we all saw the spectacle that unfolded when he started asking questions yesterday and then ultimately stormed out of the room.
Yeah, stormed out. It seemed more toward the chairman than toward Jackson herself. I think that was part of the conversation that we saw this morning, with Republicans taking issue with the chairman's so-called editorializing, in their words. But yeah, Lindsey Graham always puts on a bit of a show, right? We always are interested to hear what certain senators tend to put on a bit more drama in these than others. Lindsey Graham coming up next. There was another part of the hearing that I found particularly interesting, and this was a line of questioning having to do with freedom of speech and the First Amendment in general. And we heard Judge Jackson Kate say, stressing defining the First Amendment and stressing the importance of the First Amendment, but then also explaining the exception of if speech is meant to incite violence, that is where it no longer is protected under the Constitution. But barring that, it is very important that people be allowed to express themselves. Why this line of questioning by Jon Ossoff? What are they trying to get at, or what is he at least trying to get up here with asking her about this?
Yeah, she was asked a couple of times about different important First Amendment cases. So Brandenburg versus Ohio, this important case that basically says the default is in our Constitution is in favor of protecting speech, but there are certain types of speech that can be so damaging and so destructive that they fall outside of the protection of the First Amendment. And incitement is one of the few examples of that kind of unprotected speech. But the law has basically said, in order for speech to fall outside of the First Amendment, we have to be really sure that it's not about communicating ideas, it's really about doing harm. So in order to qualify as incitement, speech has to be intended to cause and likely to cause imminent lawless action. That's the formula. And that's actually a case that President Trump invoked in his impeachment defense. Routinely, he said, I could never be criminally prosecuted for the statements I gave on the ellipse prior to the riot at the Capitol. And so the First Amendment protects anything I said on that day. So it's, and as the January 6th investigation continues, there will be questions about accountability and protection for speech. So that's very much a quite relevant case. And New York Times versus Sullivan is another one that came up. That's a longstanding protection that Judge Jackson spoke to for the press, right? Basically suggesting that if there are errors and mistakes that that creep into, press coverage only if something called an actual malice standard is satisfied. Can there be liability for those kinds of errors that the press may commit in, the ordinary coverage?
Right.
And it's an important protection. And so she spoke to both of those, and both of those cases have been questioned by various members of the Supreme Court, in particular New York Times versus Sullivan. So the doctrine, could be subject to re-examination, but they're both really important sort of First Amendment cases, and I like the law school clinic that she seemed to be putting on in response to some of those questions.
It does feel like we learn more about the law just in watching these hearings, and we just saw Judge Jackson walking through the hallways, making her way to the hearing room. Devin, what are you looking out for as this period of questioning resumes?
Well, I'm looking to see, Diane, whether the attacks that Republicans launched yesterday will keep the same momentum, whether Lindsey Graham, Ted Cruz, Josh Hawley will continue to go at her at some of the same lines of questions on the child porn cases and critical race theory that they brought up yesterday. Will that continue, or will they dial it back now and pivot away? And we will see in very short order just which way they're going to go. I think it certainly will define the rest of the second day of questioning.
And Brittany, any particular areas or topics you're looking to hear about?
Beyond looking and seeing what Cotton Cruz and Hawley are going to say, I am in particular interest of how the historic moment of this nomination is going to be captured. We heard John Ossoff give Ketanji Brown Jackson a little bit of that time today, but as the first black member of the Supreme Court, you cannot overstate the importance to other black and brown lawyers, little kids, brothers, sisters, family members around the world who are eager to tune in. So curious how she characterized that and other members of the committee characterize it for the next, let's say, 7 hours that we have left.
So it looks like Judge Ketanji Brown Jackson taking her seat, and Senator Durbin is calling the hearing back into session. Let's listen.
Good morning, Judge. Thank you.
Sorry. Good morning, Senator.
I want to comment on the last exchange. And Judge, this is not of your making, so it's really not about you, but Representative Green, who's a fine man, came up and said he thought the exchange between you and Senator Leahy at the end about the arc of time and how far we've come as a nation was powerful. I agree. And I guess here's my point I'm trying to make to the American people, to my Democratic colleagues. I wish you had that same attitude when an African-American conservative is appointed to high office in the judiciary. So what happened with Janice Rogers Brown? In 2003, she was an African-American nominee for the D.C. District Court, 54 years old, a little bit older than you, but pretty close. She was a daughter and granddaughter of sharecroppers, a childhood in Alabama under Jim Crow. She was a single mother, a member of the California Supreme Court. Instead of celebrating how far we've come, my Democratic colleagues filibustered her ascension to the D.C. Circuit Court. Because it's well known on our side that we were very much considering her to be the first African-American woman on the Supreme Court. So rather than this wonderful exchange, which was wonderful, Representative Green, where were you and others when there was a wholesale assault on her nomination? Nowhere to be found. The filibuster was used for 2 years to stop her nomination, and we eventually did the Gang of 14, of which I was a part, so that she could make it through after 2 years of waiting. This is what the current president said when he was in the Senate, Joe Biden, asking about her, Janice Rogers Brown, being on the Supreme Court. I can assure you that would be a very, very, very difficult fight, and she probably would be filibustered. That's what he said about an African-American conservative nominee by President Bush who had served 5 years on the California Supreme Court. We're not going to live in America like that any longer. To my Democratic colleagues, if you're a person of color, a woman, supported by liberals, it's pretty easy sailing. But if you're Miguel Estrada, Janice Rogers Brown, Amy Coney Barrett, on and on and on, your life gets turned upside down. You had nothing to do with that. I just make this observation that when you come up to me and talk about how moving the exchange was, I agree. And I just want to remind you, there was somebody else of color, a woman of color, that was picked for the D.C. Circuit, one of the highest courts in the land, that did not meet the same fate. And those days should be over. Do you believe illegal immigrants should be allowed to vote, Judge Jackson?
Thank you, Senator. Under our laws, you have to be a citizen of the United States in order to vote.
So the answer would be no.
It's not consistent with our laws, so the answer is no.
Okay, why do they do that in New York?
Senator, I'm not aware of the
Okay,
circumstances.
all
that
right,
you're-
well, that's a good answer. The answer is no. Can an unborn child feel pain at 20 weeks in the birthing process?
Senator, I don't know.
Are you aware of the fact that anesthesia is provided to the unborn child at that time period if there's an operation to save the baby's life because they can in fact feel pain? Are you aware of that?
I am not aware of that.
Well, that may come before you one day, so just keep an open mind. That's the only thing I ask you to do. You said just a bit ago that you apply the law and the facts and call them as you see them. Is that right?
That is correct, Senator.
Okay, and you look at the statute as the way it's written, and you try to apply it in its plain meaning. Is that correct?
That is correct, Senator.
Have you heard of a case called Make the Road versus McAleen?
Make the Road New York? Yes.
Yeah, okay. Make the Road in New York, who are they?
Make the Road New York is a nonprofit that represents various individuals in the sort of immigration law field.
They're a nonprofit advocacy group for immigration issues. Did you know they received large donations from the Arabella Network and from George Soros's Open Society Foundation Network?
No.
Okay, well, they did. Now, in that case, what was the issue?
The issue in that case was a challenge to a change in administration policy concerning expedited removal, which is a policy that Congress enacted in order to expedite certain removals in the immigration system. Ordinarily, before expedited removal.
Well, asylum cases do not fall in this category, right?
Well,
Trust me on that, because the statute says it doesn't.
if a person who could otherwise be subject to expedited removal makes and has a credible fear of torture in their country, they can be
And can they make that claim?
determined. They
Right.
can be determined
Right.
to qualify for regular removal rather than
Right.
expedited removal.
So expedited removal is a creature of Congress, folks. And if you've been here 2 years or less, the statute, the statute would allow the administration in office to have expedited removal, avoiding a lot of the hurdles that would exist otherwise for people here 2 years or less. So in the Obama, even Bush years, they did not look at it in terms of applying it to everybody. Some people coming by air got expedited removal, others didn't. The Trump administration decided to use the authority given to it by Congress to remove all eligible cases 2 years or less under the expedited removal statute. Is that a fair summary?
Well, Senator, I would say it differently.
Well, say it differently.
All right. The statute that you've put up indicates that Congress is giving the department, it says the Attorney General, but now it's the department,
Right.
the ability to determine what category of aliens.
If you've 2 years or less.
Yeah, but importantly, the authority was, it was not Congress saying 2 years or less. What Congress said is, you, agency, have the authority to determine what category of persons who have been here between 0 and 24 months.
Which is
should
2
be.
years, yeah.
No, but forgive me,
So-
Senator, what I'm trying to explain is that the authority given to the agency was to determine what
They
length
had
of time.
discretion to make that decision.
What length of time? It was not the authority to deport everyone who's been here for 24 months. It was the authority to determine what length of time a person has to be here in order to be subjected to expedited removal.
Here's what the statute said. The Attorney General, which is actually the DHS Secretary, may apply clauses 1 and 2 of this subparagraph to any and all aliens described in subclass 2 as designated by the Attorney General, actually DHS. Such designation shall be in the sole and unreviewable discretion of the Attorney General and may be modified at any time. Now, I've been in this business for quite a while. What the Trump administration did was to use the discretion given to it by statute in a way different than prior administrations. This advocacy group, the Arabella-supported advocacy group, tried to strike it down. You rule for them. Here's what the D.C. Circuit Court said about your ruling. There could hardly be a more definitive expression of congressional intent to leave the decision about the scope of expanded removal within statutory bounds to the Secretary's independent judgment. The forceful phrase, sole and unreviewable discretion, by its exceptional terms. Such designation shall be in the sole and unreviewable discretion of the Attorney General and may be modified at any time. To those of us in the law writing business, I don't know how you could tell a judge more clearly that the administration, the agency in question, has discretion to do certain things within the statute. So this is an example to me, and you may not agree, where the plain language of the statute was completely wiped out by you. You reached a conclusion because you disagreed with the Trump administration, and the D.C. Circuit Court of Appeals said, as I've quoted just a minute ago, there could hardly be a more definitive expression of congressional intent to leave the decision about the scope of expedited removal within the statutory bounds to the Secretary's independent judgment. That, to me, is Exhibit A of activism. Let's go back to the child pornography cases.
Senator, would you allow me to?
Yes, please.
Thank you. The statute and the circumstances that you reference are accurate insofar as that is what the statute says. It's not all of it. It doesn't describe the designation process that I was trying to articulate. And it doesn't address the fact that Congress has another statute that is presumptively applied in agency cases to tell agencies how to exercise discretion. There's also D.C. Circuit case law that says that in addition to having that procedural statute be presumptive, even very clear designations of authority to an agency may still be subject to Congress's other directions regarding how to exercise the discretion.
That argument fell on deaf ears.
Understood. That's our appellate process.
I've got other things I want to talk about. You've given an explanation, but it didn't work. The D.C. Circuit Court said there could hardly be a more definitive expression of congressional intent. This is good as it gets. There's no way to write a statute saying discretion lies in an agency. It's sole. It's non-reviewable. So you're not convincing me that
With
this was
respect,
anything
Senator.
other than activism, and we can talk about it all day long, but I agree with the D.C. court. This, to me, is an example, Exhibit A, of a judge ignoring limitations placed in the law by Congress to get a result they wanted. Child pornography. I have no doubt that you find child pornography disgusting as the rest of America. You're a mother. You seem to be a very nice person. Are you aware of how many images are out there on the internet involving children and sexually compromising situations?
Senator, I'm not aware of the numbers, but I've seen the images in my
And they are disgusting,
role
right? Well, let me
as
tell you
a
the
judge.
numbers. In 2021, the National Center for Missing and Exploited Children Cyber Tip Line received 29.3 million reports of apparent child sexual exploitation containing 85 million images, videos, and other files. That's in 2021. It's up. In 2019, it was less. So there's an epidemic of this on the internet, that if you go out on the internet, there are millions of pictures of kids being abused. When it comes to sentencing child pornography possession cases, do you routinely discount the fact that a computer was used?
Thank you, Senator, for allowing me to address this concern. The guidelines related to child pornography were drafted at a time in which a computer was not used for the majority, if not almost all, of these kinds of horrible crimes. The guidelines have enhancements in them.
In two areas that you said you disagree. What are those two areas?
At the time that the guidelines were drafted, it was an aggravating factor, a substantial aggravating factor, to use a computer in order to distribute and disseminate the images, because the ordinary crime was not committed by computer. So the
Would you now
baseline-
agree with me that computers are sort of the venue of choice for child pornographer people?
Yes, Senator.
Okay, so here's my point. If you believe, as I do, the computer has created a bigger demand, there are more photos out there because of the internet, more websites exposing this garbage, wouldn't you want to deter people from going down that road?
Senator, this crime is among the most difficult.
No, answer my question. Wouldn't you want to deter people from going down the road of using the computer that allows these people to have access to millions of photos because of the technology? I want those people deterred.
Senator,
so if you're listening to my voice today and you're on a computer looking at child pornography and you get caught, I hope your sentence is enhanced, because the computer and the internet is feeding the beast here, that all these images out there are going to be more over time because people use computers. Now, didn't you also say that the number of images should not be considered as a sentence enhancement?
Senator, with respect to the computer, one of the most effective deterrents is one that I imposed in every case and that judges across the country impose in every case, which is substantial supervision. Any of these
wait a minute, Judge. You think it is a bigger deterrent to take somebody who's on a computer looking at sexual images of children in the most disgusting way is to supervise their computer habits versus putting them in jail?
No, Senator, I didn't say versus.
That's exactly what you said. I think the best way to deter people from getting on a computer and viewing thousands and hundreds and over time, maybe millions, the population as a whole, of children being exploited and abused every time somebody clicks on, is to put their ass in jail, not supervise their computer usage.
Senator, I wasn't talking about versus.
You just said you thought it was a deterrent to supervise them. I don't think it's a deterrent. I think the deterrent is putting them in jail.
Senator,
Does
would you let
sentencing
her
have a
respond?
deterrent component?
Senator, would you let her respond?
Yes. Does sentencing have a deterrent component?
Yes, Senator, deterrence is one of the purposes of punishment, and Congress has directed courts to consider various means of achieving deterrence. One of them, as you've said, is incarceration. Another, as I tried to mention, was substantial periods of supervision once the person...
So if I could, may ask you, in your view, it's more of a deterrent to have somebody substantially supervised in terms of their computer use who's looking at child pornography than it is to put them in jail?
Senator, I'm not saying it's more or
That's
less.
exactly what you're saying.
What I'd like to point out is that if we're going to... Let me say it this way. Congress has authorized courts to use a number of different means to achieve the purposes of punishment.
And one of them is an enhanced punishment by using a computer.
The enhancement with respect to using a computer relates to the penalty in terms of incarceration.
And you would choose not to apply that in these cases. You've said that. I'll read you the quote, but you've decided not to apply the use of a computer as an enhancement. You've also said you're not going to hold the number of images that the person has looked at as a sentencing enhancement factor. Is that true?
No, Senator, it's not the number of images that the person has looked at because we don't have that information.
Well,
it is the number of images that they've either received or distributed that are...
we don't know if they looked at them, but you're not going to hold it against them that they received 10,000 images versus 100.
That's not what I've said, Senator.
Well, here's what you said. I've decided to apply my general policy disagreement with respect to those enhancements, at least that is the computers and the number of images. Folks, what she is saying, the reason she's always below the recommendation, I think, is because she doesn't use the enhancements available to her. She takes them off the table. And I think that's a big mistake, Judge. I think that every federal judge out there should make it harder for somebody to go on a computer and view this filth. That if you use that venue, which is the venue of choice for all these child pornography cases, that you use it against them. I think the more you download, like drugs, the more you have, the more you should go to jail. You've made a conscious decision to disregard those two enhancement sentencing factors, and I think that is a wrong way to go in terms of deterrent. To me, putting somebody in jail for using a computer is more of a deterrent than supervising their activity of watching the computer. That's just a difference that we have. I know I'm out of time, and listen, you've lived an incredible life, but here's one thing that won't happen to you as we wrap this up. How would you feel that if I'd had a letter from somebody accusing you of something, a crime or misconduct, for weeks, and I give it to Senator Durbin just before this hearing's over, and not allow you to comment on the accusation? How would you feel about that?
Senator, I'm not sure. I don't understand the context of the question.
Well, did you watch the Kavanaugh hearings?
No, sir.
Are you familiar with what happened in the Kavanaugh hearings?
Generally.
Senator, your time is...
Well, please, Mr. Chairman. So to be honest, it's a minute and 47 seconds. She filibustered every question I had, and she has a right to give an answer, but I'm trying to make a point in 20 minutes. You were here for Kavanaugh. If she's confused about what happened, some people on the other side had an accusation against Judge Kavanaugh that during high school, he sexually assaulted somebody. And the rest is history. That was known to the people on the other side and never revealed during the meetings they had with Judge Kavanaugh. It was literally ambushed. He was ambushed. How would you feel if we did that to you?
Senator, I've appreciated the kindness that each of you has shown me to see me in your offices, to talk with me about my approach.
But my question is, what if during our 15-minute exchange, it was very pleasant. You're a very nice person. You have a lot to be proud of. I would never do that to you. If I had some information that's sketchy at best, that somehow you've done something wrong, I promise you, just from human decency, I would share it with you. I would not disclose it at the last minute of the last day of the hearing, and I've already given it to a newspaper so the whole country can read about it before you ever said a word.
Senator, she's had nothing to do with the cause.
No, but I'm asking her about
you won't even let her finish
how
your
she may
response.
feel about what y'all did.
Could we have order,
Senator, your
Mr.
time
Chairman?
has expired, and I'm going to give her an opportunity to finally complete an answer.
So, if I could
Just
address,
answer the question.
Senator, I don't have any comment on what procedures took place in this body regarding
What'd you think
Justice
about the Kavanaugh hearing?
Kavanaugh.
Would you
What
let
I'd
her
like to
finish?
answer is your points about my sentencings in child pornography cases. The point of the guidelines is to assist judges in determining what punishment to provide in cases. And there are horrible cases, but the idea is that between the range of punishment that Congress has prescribed, judges are supposed to be providing proportional punishment based on what a person has done. The sentencing scheme doesn't place everybody at the same level. The point of judging and the guidelines is to look at what has happened in a case, compare defendants to each other in terms of what they've done, and give proportional penalties based.
Mr. Chairman, this is she has said, Mr. Chairman, she does not use sentence enhancements in the area of somebody using a computer for everybody.
Can I explain why, sir?
I'm going to give the witness an opportunity to respond to you, Senator.
Finally.
At
Why?
the time that the guidelines were created for child pornography, this crime was primarily being committed by people who were literally mailing 1, 2, 5, 10, 100 photos at a time.
How's it being committed now?
Would she please
Go
let
ahead.
her complete her answer?
Go ahead.
As a result, the commission determined in the guidelines that it was a substantial aggravating factor if the facts of the case demonstrated that someone had been distributing hundreds of images, because what that meant was over this long, maybe it was a long period of time, they had collected one photo at a time, they had amassed it, they had potentially mailed one at a time, and that showed really aggravated, terrible conduct. I'm not saying as a baseline it's not terrible, it's all terrible. But what we're doing is we're differentiating among defendants. So in a world in which the mail is used for the purpose of distribution, it really matters whether the person has distributed 1 or 5 or 1,000. And so the guideline says, you know what? We are going to treat a person who's distributed 1,000 a lot worse, because that shows that this person is really engaged in this really horrible behavior. In comes the internet. On the internet, with one click, you can receive, you can distribute tens of thousands. You can be doing this for 15 minutes, and all of a sudden, you are looking at 30, 40, 50 years in prison.
Good. Good.
I understand.
Absolutely
Senator,
good. I hope you are.
To do
Good.
Allow her to finish, please.
I hope you go to jail for 50 years if you're on the internet trolling for images of
Please.
children in sexual exploitation. So you don't think that's a bad thing? I think that's a horrible
That's
thing.
not what the witness said, and she should be allowed to answer this question once and for all.
Senator, all I'm trying to explain is that our sentencing system, the system that Congress has created, the system that the Sentencing Commission is the steward of, is a rational one. It's a system that is designed to help judges do justice in these terrible circumstances by eliminating unwarranted disparities, by ensuring that the most serious defendants get the longest periods of time. And when modes of commission of the crime change, such that in 2 seconds, someone can receive or distribute thousands of images. That's no longer and this is what the commission found in their studies, an indicator of a person who, relative to other people, has committed this crime in a more aggravated way.
Well,
and so what we're trying to do is be rational in our dealing with some of the most horrible kinds of behavior. This is what our justice system is about. It's about judges making determinations in meting out penalties to people who have done terrible things.
It is not rational to take the venue of choice of child pornographers, the computer that have 85 million images on it, and not consider that feeding the beast. We're trying to get people to stop this crap. So when you troll on the internet and you pull down thousands of images of children from the internet, I want you to stop that. I want people to go to jail who do that because you're feeding the beast. We have a bill here, the Earn It Act, that would allow the victims who are on the internet over and over again to sue the media companies that provide these images. We have a fundamental differences of how you deter crime. I think the best way you deter crime when it comes to child pornography is you lower the bloom on anybody who goes onto the internet and pulls out these images for their pleasure.
Senator, every person in all of these charts and documents I sent to jail because I know how serious this crime is. Every person, I discussed the harm of these terrible, terrible images to the victims who are portrayed in them. I talked about what this crime does to the children who are being abused in these photos, and on the other side of their terms of imprisonment, I ensured that they were facing lengthy periods of supervision and restrictions on their computer use so they could not do this sort of thing again. That's what Congress has required of judges, and that's what I did in every case.
You always were under the recommendation of the prosecutor, many times the parole people. And to be honest with you, Judge, a 32-year-old man who sent an image of his own 10-year-old daughter, you substantially reduced the not only the guidelines, but the recommendation. And all I can say is that your view of how to deter child pornography is not my view. I think you're doing it wrong, and every judge who does what you're doing is making it easier for the children to be exploited. If you're on a computer right now looking at a kid in a sexually compromising situation and you get caught, I hope nobody gives you a break because you used the computer.
The conduct that's been described is reprehensible, and I think everyone in this room agrees. And the fact of the matter is that I'm co-sponsor of your bill, the Earn It Act, and I believe that we should be doing our job here. But part of our job, we've failed in responding to the changing circumstances that face this crime. What has it been, 15 or 16 years? She is currently not an outlier in sentencing. 70% of the federal judges face the same dilemma and wonder why Congress has failed to act and when it will act.
This is our fault?
Partially it is, Senator. To be honest with you, it is. We have to upgrade these guidelines and decide whether we're going to stick with the Supreme Court decision that they're not mandatory. Senator Feinstein.
Thank you very much, Mr. Chairman. I would like to compliment the witness. You've been answering, I think, close to 15 hours worth of questions. And I know how difficult this is and hard it is. But I just want you to say in this senator's, know that in this senator's eyes, you've handled it very, very well. So
thank you, Senator.
And I'll move on to my questions. Congress has recognized how important it is for crime victims to participate in the legal process. And one example is the Crime Victims' Rights Act, which I authored with Senator John Kyle in 2004. That law provides certain rights for victims at critical stages of the legal process. The right to be notified, to be present, to be heard, among others. And I understand that in your 8 years as a district court judge, you would carefully consider victim impact statements when imposing criminal sentences. Could you tell us a little bit about this and how you considered crime victims in making your sentencing decisions as a judge?
Thank you, Senator. As you say, the law provides for victims to have an opportunity to address the judge, to address the court, to explain the harms that happen as a result of criminal behavior. And in the time that I was a trial judge, I found it to be a very important part of our criminal justice process because my sentencings were about handing down consequences for the behavior that defendants had engaged in and making sure that the defendants who received those consequences understood that they were getting those consequences because of the harm that they had caused. And so what I felt was important for promoting the purposes of punishment, which is what Congress has required of judges to do, is to ensure that the harms were made clear to the defendant in every case. So I had, for example, a case involving robbery. There were two, it was a single defendant who committed 2 robberies, one in April and one in September, of the same small pharmacy in DuPont Circle, which is not far from here. It's a small independent pharmacy selling pharmaceuticals, and this person decided that he was going to rob the pharmacy of their oxycodone and other kinds of prescription drugs for sale. That's a sort of standard scenario that we see in the federal system, but what was so particularly egregious in this case is that this defendant was so bold in his robberies. He came in April with a gun. He held the employees hostage, essentially, forcing them to open the safe with the drugs in it at gunpoint, stole the drugs. Not masked, not hiding his identity. And this is pre-COVID, so we're not talking about having to have a mask. He was a robber, plain and simple, with no fear of people identifying him. And then, in the period between April and September, he would come back to the pharmacy. He would loiter outside on the street. This is according to the victims. They would see him looking in the window. Once or twice, he came inside, looking like he was going to buy something and staring them down. And they knew who he was, and they called the police, and they weren't able to apprehend him because he hadn't really done anything at that point. And the people who worked in the pharmacy were terrified, and they were terrified by that behavior, the menacing nature of it. By the time we get to September, he actually comes in, and they think maybe this is another time when he's just loitering, but no, he pulls out a gun, he hops over the counter, he assaults one of the people who are working there and steals the drugs again. And that time they were able to call the police in enough time for them to come and apprehend him. So at his trial, he did not try. He didn't go to trial.
You're the judge?
I'm the judge. He pled guilty to this behavior, which was well documented. There was no defense that it wasn't him. But the guidelines in the case and the statutes that applied said because he used the gun, he was supposed to get something like 7 years. And I used the victim's statements to, first of all, explain to him how he had terrorized the people. Their statements said things. One woman said, I can't work at the pharmacy anymore because I am so fearful that this guy will come back. It's changed my whole life. It was a whole set of really horrible circumstances that I read to him at his sentencing so that he could understand what he'd actually done. And then I sentenced him above the requirement of the law because I thought it was warranted to make clear to him that this was a terrible, terrible thing that he had done to these people. So the victim statements were really important because they explained to me and to him the consequences of his behavior, but beyond just how many drugs he stole or the fact that he used a gun. They were the real life circumstances that resulted from his behavior, and it was important for him to understand that.
I've listened to most all of this testimony, which I think now you've gone on for over 15 hours. And I just want to say that I think you have a stamina and a very good brain and a real sense of empathy has been communicated to me in these 15 hours. And I want you to know that. One perception of the Supreme Court has turned increasingly negative over the last few years. A recent Pew Research survey found that 44% of adults have an unfavorable view of the Supreme Court. Less than 3 years ago, that number was 30% of adults that held that view. And I understand that as a judge on the D.C. bench, you have frequently accepted invitations to speak at public events in the hopes of giving the public more information about the judicial process and more confidence in the outcome. So here's the question. Why do you think there's been a decline in the public's perception of the court? And if you are confirmed, how would you strive to improve the public's confidence in the court and its decisions?
Thank you, Senator. I think that public confidence in the court is very important. It is, it's crucial to the rule of law that the public believe in the judicial process and therefore choose to accept the rulings of the courts, not just the Supreme Court, but all of the courts. It's part of the way our process works. And I think that I have taken that to mean, in terms of my role as a judge, that outreach to the public to explain what it is that we do, to inspire, hopefully, law school students and high school students, young lawyers in law firms and elsewhere, to think about careers in the judicial branch or think about careers in law as one of the ways that I have attempted to try to shore up public confidence. And if I'm confirmed, I would plan to continue as best as I can to do that kind of thing, because as you say, it's very important for the public to understand the work of the court and to follow its pronouncements concerning the law.
Earlier, when you and I spoke in my office, we discussed some of the people who have mentored you throughout your career, and one of those was Judge Patty Saris. You served as a law clerk for her on the Massachusetts District Court, I believe, early in your career. And you've spoken publicly about the role she has played as a mentor in your legal career. You have described her as, quote, a consensus builder, a good listener, a careful speaker, the essence of judicial temperament, end quote. So would you share with all of the members here more about how Judge Saris's approach to judging and her mentorship have shaped you and your career? If you give some of the specifics, yes, I think everybody would be interested.
Thank you, Senator. As I reflect on her mentorship and also the mentorship of my other two judges, it's very interesting because I think I learned maybe different things from each of them. Judge Saris, who was my first clerkship. You're correct. She's serves on the District Court of Massachusetts, which is the trial level court. I learned how to look at the facts in a case from Judge Saris. That's part of what the trial court level does. We, as trial judges, develop the record in a case, take testimony, have trials, and she is extraordinary at developing a record and making sure that all of the relevant facts are adduced from the witnesses and considered in the context of her trial and record responsibilities. And so that, I think, is something that I learned from her in terms of the law, and her warmth and care for her law clerks meant that she has been a lifelong mentor to me. And ironically, she became the chair of the Sentencing Commission after I had been on the Sentencing Commission. So we worked together later in my career. So I often use that story to tell young people, you know, you never know what's going to happen. Someone who you worked for at some point might be your colleague down the line.
Well, let me just one more. You've handled a large number of cases during your career, both as an advocate and a judge. As an advocate, you've worked on a very wide variety of cases, from work for corporate clients during your time in private practice to your work for low-income clients during your service as a federal public defender. And during your 9 years as a federal judge, you've written nearly 600 opinions. I think that's really quite a sterling record. And I imagine that some of the cases have really stuck with you. And so I would like you, if you can, to talk a little bit about some of the cases, maybe one or two, that you've had that have made a deep impression and have really enabled you to progress as you have.
Thank you, Senator. Well, as you say, I have handled a lot of cases in my time, nearly decade on the bench, and you learn something in almost every case in some respect. If you're doing your job right and you're looking into all of the issues. I think there might be, I'd mention one from sort of a few years into my service as a trial judge. I handled a case, Yakai versus Napper. And the case involved trademark infringement. And you would ordinarily think that trademark infringement charges are dry and technical. And what I learned from this case is that even areas of the law that you might think apply only to businesses impact real people at times. So this case involved a small community, a cultural community of people who believe in vegan lifestyles. They call themselves the African Hebrew Israelites, but it's not a religious community. It's a cultural community around healthy living. And they have created a restaurant and a series of restaurants here in the Washington, D.C. area with menus involving really, I'm told, terrific vegan foods. And in this community, there was a member who was the one who created the recipes and who was responsible for the restaurant. The whole community had other aspects to it. He ended up falling out with the community, and the dispute involved his actions essentially taking over the restaurant and reopening it by himself using the same name. The restaurant was called Everlasting Life, which was a important phrase for this community, and he essentially ejected the other members because he was the leaseholder, or he had signed the lease on behalf of the community, and he kicked them out for a day, and then he reopened the restaurant using the same name. And so the question was, under the Lanham Act, which is the statute for trademark violations, the question is whether there is a potential for confusion in that sort of circumstance. But ordinarily, I see Senator Coons nodding, ordinarily, when you have a trademark infringement, you're talking about two different businesses who have very similar products. And the question is, you know, are they similar enough to cause confusion? Because the idea of the law is that people should be able to have products that are identified with them, and you shouldn't be confused. And in this case, we had a bench trial about it, but it was pretty clear. I was the fact finder as the judge. It was pretty clear that when you open the same business with the same name, using the same recipes and food, that you have created this kind of problem that is a trademark violation. But what was so interesting to me about the case, in addition to the fact that I got to be the fact finder, it was a bench trial, was that we had witnesses come in who testified about the circumstances. This was a very small community, and they all knew each other, and the testimony about what it meant to them to have one of their members ejected in this way and then have him turn on them was very, very moving in the courtroom. So even though we were talking about this kind of arcane area of the law, it was real circumstances that were happening.
Well, stop for a minute, because I think you're a very important addition to the court. And what I'm trying to fathom out from the hearing is, what kind of judge will she be? How will we look at her in 5 or 6 years? And so what I really want to ascertain is what kind of a judge you will be. What will be the principles you hold dear, and how will you function in this capacity? If you could just answer that one question, I've been waiting for it for about 15 hours, so I'd appreciate it. Thank you.
Well, I would hope to be the kind of judge that I have been during this last decade. I have been the kind of judge who understands that it's my responsibility to rule neutrally, to not have any agenda when I'm looking at a case. I've been the kind of judge who understands that facts matter. Facts like the ones that I was just describing, and that it's important for a judge to take into account and be able to understand the arguments of all of the different parties and participants. And I've been the kind of judge who takes my responsibility to not be a policymaker, to try to understand and ascertain the will of Congress, if it's a statute, or to adhere to my own, I've been saying, stay in my lane, to not exert my authority beyond what the Constitution requires when I'm interpreting and applying the law. I think I've been the kind of judge who lives up to the oath in terms of being fair and impartial, ruling without fear or favor, and ruling consistent with Article 3.
Thank you. Thank you, Mr. Chairman.
Thank you, Senator Feinstein. Senator Cornyn?
Good afternoon, Judge. I understand I'm the last one, maybe before lunch, so if your blood sugar is getting a little low, you can think about having a little break. But just because the chairman keeps bringing this topic up, let me just ask you one question. When you accuse somebody of a crime, are you calling them a criminal?
Oh, Senator, I haven't accused anybody of a crime.
That's not my question. When in common understanding and in plain English, if you accuse someone of a crime, are you accusing them of being a criminal?
It depends on the context. It depends on what else you say about them. It depends on the circumstances.
It depends on the circumstances.
Yes.
So you put this in the same category as defining what a biological woman is.
No, I'm
You're
just,
really not sure.
I didn't say I wasn't sure. I said it depends on the
So
circumstances.
you are sure?
No, I said it depends on the circumstances that you're positing as to whether or not you're calling someone a criminal.
I just don't think that's credible, Judge. Let me ask you another question. You talk about the public confidence in the courts, in our institutions, which I agree are very, very important, that the public has confidence in our judiciary. Would you agree with me that to the extent that people perceive that judges, unelected, lifetime tenured judges, are making policy pronouncements or political decisions, that it undermines public confidence?
I do.
Thank you. Yesterday, we talked a little bit about precedent, and I know Senator Feinstein, as she does in these hearings, talked about super precedent, and in particular, Roe versus Wade. And I want to talk a little bit about that, but first, let me just ask you, do you think there's any good reason for the Supreme Court not to overrule a previous decision when they've concluded that that decision was wrong?
Thank you, Senator. Again, it's hard for me to answer that question in the abstract. What I'll say is that the Supreme Court has laid out factors beyond just the precedent being wrong as a reason to overturn it.
Well, we talked a little bit about this yesterday. The Supreme Court revisited the issue of separate but equal, which was the law, the constitutional interpretation of the Supreme Court under Plessy versus Ferguson, and overruled that precedent because
Yes.
it concluded it was wrong, right?
I haven't looked carefully at whether all of the different factors that the Supreme Court now uses to overturn were discussed in the opinion. But now the Supreme Court's precedent is to overturn on the basis of a number of different factors and not just whether or not it's wrong.
So are you suggesting that the Supreme Court could not or would not overrule a precedent that it determined was wrongly decided?
No, I'm suggesting that the Supreme Court's case law indicates that it looks at multiple factors.
No, I understand. You go through the stare decisis analysis,
Yes.
right?
Yes.
But if it's wrong, that's one of the factors that you consider, right?
Yes, but it's not the only one.
So are you suggesting that there may be circumstances under which the court determines its previous decision is wrong, but it will not overrule it?
The fact that there are multiple factors indicates that the court looks at more than whether or not it's wrong.
Okay. So so you would say, if I'm interpreting you correctly, that if the court concludes its previous decision is wrong, it won't necessarily overrule that. It applies a multi-point analysis.
Yes, I think that's
Okay.
accurate.
Back when Roe versus Wade was decided in 1973, generally speaking, the court said that the states may not limit access to abortion pre-viability, but post-viability, there could be some restriction on the right to abortion. Is that generally the?
As a general matter, yes.
Okay, thank you. Okay. Well, and then I think it's since 1973, the question of viability has risen again, what that actually means, because now viability was around 28 weeks. That is, the fetus could live outside the womb. But today, because of the advances in medical science, the fetus can live outside the womb after about 23 weeks. Is that your understanding?
Senator, I haven't studied this, so I don't know a number of weeks in the way that you're
Okay.
saying.
Well, let's talk a little bit about viability. The line that was drawn for pre-viability and post-viability analysis by the courts. What does viability mean when it comes to an unborn child, in your understanding?
Senator, I hesitate to speculate. I know that it is a point in time that the court has identified in terms of when the standards that apply to regulation of the right.
Justice Brennan, at a later point in his career on the Supreme Court, admitted that the viability line was an arbitrary line. Do you agree with him?
Senator, I'm not able to comment on viability. There's a case pending in the Supreme Court right now concerning the issues.
I'm asking you about previous decisions, but I hear you. No one suggests that a 20-week-old fetus can live independently outside the mother's womb. Do they?
I don't know.
I mean, the child will need to be fed or sheltered and all the other essentials to sustain human life. So there's no suggestion that after 20 weeks that a child can live independently, correct?
Senator, I'm not a biologist. I haven't studied this. I don't know.
You don't know whether an unborn child could live outside the womb at 20 weeks gestation?
What I know is that the Supreme Court has tests and standards that it's applied when it evaluates regulation of the right of a woman to terminate their pregnancy. They have the court has announced that there is a right to terminate up to the point of viability, subject to the framework in Roe and Casey, and there's a pending case right now that is addressing these issues.
The Constitution doesn't mention the word abortion, correct?
That's correct.
Just like it doesn't mention the word marriage, correct?
That is correct.
And so as you and I discussed, perhaps ad nauseum yesterday, when we were talking about substantive due process, this is one of those unenumerated rights that the court has created, court-made doctrine or law, and creating a constitutional right, even though it's not explicitly mentioned in the Constitution itself. Correct?
The court has interpreted the due process clause of the 14th Amendment to include...
Right. We talked about substantive due process yesterday, and that's what this is, right? The Supreme Court cases that deal with the right of abortion is a result of substantive due process analysis like you and I talked about yesterday.
Yes.
Okay. In the, you remember when you were confirmed for the Court of Appeals, in that process, we had a hearing, and then we sent you questions for the record, what we call QFRs around here.
Yes.
And one of those, question number 10, was, does the Constitution protect rights that are not expressly enumerated in the Constitution? As part of your answer, you mentioned Roe versus Wade and Planned Parenthood versus Casey, and you said this, and I'll quote, "They articulate a limited right to terminate a pregnancy." What is the limitation that you understand that was pronounced in Roe versus Wade and Casey when it comes to a right to terminate an abortion? What are the limitations under current law?
Under current law, as I understand it, there are limitations insofar as there can be regulation of that right pre-viability unless the regulation imposes an undue burden on the exercise of the right, and there can be regulation after viability, as long as there's exception for the health and I think maybe life of the mother. So it's the limitations are about whether and to what extent the government can regulate the right.
Is it your understanding under the current precedent of the Supreme Court that there is a right to abortion up to and including the time of delivery of the child?
Senator, I don't know, actually. I mean, the Supreme Court in every case is looking at individual regulations of the government related to individual rights. And I am not aware of the court having made a pronouncement about whether or not regulation can extend all the way up until birth. I'm just not aware of that. And that it's because the court is looking at individual cases and making its rulings in the context of individual cases and not making sort of pronouncements in general.
So you are suggesting that in some individual case, the right to abortion could extend through the entire pregnancy up until the time the child is delivered?
No, Senator, I'm suggesting that I'm not aware of any case that's handled the issue.
You told us that you think that you believe Roe versus Wade and Casey are precedents, and we talked a little bit about some of the questions about whether it's a super precedent and the like. Are you familiar with the Supreme Court's decision in the Heller case?
I am.
And that was a decision by the United States Supreme Court that recognized the individual right to keep and bear arms under the Second Amendment, correct?
Yes.
Is that a precedent of the court?
It is.
And you would respect that precedent?
Yes, Senator. All precedents of the Supreme Court have to be respected.
Is it equivalent in terms of its precedence to Roe versus Wade, or would you evaluate it differently?
I'm not aware of any ranking or grading of precedents. All precedents of the Supreme Court are entitled to respect on an equal basis.
I agree with you. That's why it kind of blows my mind when people talk about super precedents, as if somehow one precedent was different in terms of its significance or priority under the Constitution than others. In the short period of time I have remaining, let me just revisit with you some of the questions we talked about yesterday with regard to free exercise of religion. And of course, that's recognized explicitly under the United States Constitution, the First Amendment, correct?
Yes.
Okay. Are you familiar with the cases that have been litigated before the Supreme Court of the United States involving the Little Sisters of the Poor with regard to the Affordable Care Act mandate on contraception coverage?
Yes.
Okay. Now, the Little Sisters of the Poor are a benevolent group of nuns. I think there are about 300 of them that take care of elderly and infirm individuals. And of course, as a matter of their religious beliefs, as documented in the court's opinions, they don't believe in either contraception or abortion. Do you agree with that?
I believe that was described in the case that you're talking about.
I think that's right, too.
Yes.
Yeah. And so when the Affordable Care Act mandated that every health insurance policy contain coverage for contraception, or chemically induced abortions, they objected and said that this violated their conscience and their free exercise of religion rights under the First Amendment, right?
I believe so, yes.
Well, after the Obama administration, during the Trump administration expanded the regulations to allow not only churches, but also religious organizations like the Little Sisters of the Poor a waiver from that contraception and an abortion-inducing drug mandate. Do you recall that?
Yes.
Are you familiar with the fact that President Biden has said he would restore the previous regulation and that was promulgated under the Obama administration and exclude organizations like the Little Sisters of the Poor from that waiver potential for abortion drugs or contraception coverage?
I am not aware of that, Senator.
Okay. Well, I guess what all this boils down to, Congress passed a bill called the Religious Freedom Restoration Act, which tried to make sure that people's sincerely held religious beliefs could be accommodated under their First Amendment rights, as opposed to Congress mandating things that would violate their conscience and violate their religious beliefs. Do you agree with me that it's important to accommodate the sincerely held religious beliefs of all Americans when it comes to legislation that the Congress may pass?
Thank you, Senator. Religious freedom is a core foundational constitutional right. It's in the First Amendment of the Constitution and reflects the Founding Fathers' understanding of this country as being one that is based on, in large part, the idea of pluralism, the idea that people can come and have sincerely held religious beliefs and practice them without persecution. That's part of the foundation of our government and the amendment that you're discussing. And as a result, that right is protected in many ways. You mentioned the Religious Freedom Restoration Act.
Right.
Congress has enacted a statute that, when it comes to federal regulation, if there's a substantial burden placed on religion, then the strict scrutiny standard applies.
I agree. I have 1 minute, so I have one more question. I agree with what you just said.
Yes.
So since I have asked this question or made this point of some of your predecessors who sat in the same chair and expressed my concern about some of the court's establishment law, establishment jurisprudence, I don't want to leave you out of that concern. When I was Attorney General of Texas, I had a chance to argue a case in front of the United States Supreme Court and called Santa Fe Independent School District versus Doe. This was a lawsuit brought by the ACLU, which sought to enjoin or prevent a student-led prayer before football games at the Santa Fe Independent School District right outside of Houston. In the end, 5 judges said that violated the Establishment Clause of the Constitution, causing Chief Justice Rehnquist to write in his dissent that the Constitution mandates neutrality toward religion, not hostility, but that the court's decision evidenced hostility towards religious expression, leaving me to conclude that the public square, we can talk about everything from violence to misogyny to sex, you name it, but we can't talk about sincerely held religious beliefs. I would just footnote that for you and plant the seed for what it's worth. Thank you very much.
Thank you.
Thank you, Senator Cornyn. Welcome to Majority Leader Schumer. Glad you're with us. and he would report, if he could, that we have a challenge to finish our hearing today at a time when we can go to the floor for a series of votes, which will end the day. So we want to stick to the schedule as much as we possibly can. I will just say that Senator Cornyn's suggestion of lunch was aspirational.
Okay.
It was an unenumerated right.
You're in charge of the agenda, Mr. Chairman.
What we had hoped to do was to take 3 more senators before we have an actual lunch.
Oh.
But it's up to you. Is that all right?
Oh, whatever you want to do. I'm open in here, happy to answer whoever would like to ask me a question.
Thank you. I appreciate that. Senator Whitehouse.
Thank you, Chairman. Judge Jackson, you can relax for a bit. I voted for you for the D.C. Circuit, and when you appeared as a potential nominee, we started doing work looking at your record and your story. We met with the president to discuss his process and his goals. When your nomination was announced, we obviously brought the work on your record more into focus, and now I've had the chance over, 15, 16 hours to see your performance in this hearing, which I think sets the gold standard for patience and courtesy. So I'm prepared to not only support you, but to let you know that I will be very proud and very honored and very excited to support you. There are 2 things that have come up during the course of the hearing, Mr. Chairman, that I'd like to take my time to have a chance to respond to. And the first has been a question, I've been through a bunch of these now. I don't think I've ever heard it come up so much. Questions about the nominee's judicial philosophy. I didn't know you needed to have one. I actually thought that when you're dealing with the Constitution, your oath of office, the constitutional precedents, and the Constitution itself kind of gave you your guide path. And when you're construing statutes, the law and the conventions of the language and your logic gave you that path. So the fact that Judge Jackson has said, I don't have a judicial philosophy, I've got a judicial methodology, doesn't bother me a bit. In fact, it kind of bothers me, the expectation that a nominee to the Supreme Court should have a judicial philosophy. Because a judicial philosophy can be a screen for a predisposition that judges, frankly, should not have, but that folks in powers and interests influential in the process may very well want them to have. So, when I think about judicial philosophy, one of them that's come up a lot has been originalism. And one of the problems with the judicial philosophy is occasional adherence, selective adherence, which in my mind makes it less of a judicial philosophy and more of a doctrine of convenience to be trotted out when it helps the people that you want to help. And originalism strikes me as being that kind of a doctrine. And the place where I think we have the biggest gap between philosophy and practice in all of this has been with respect to what I've witnessed with respect to corporate power in our democracy in the time that I have been in the Senate. If you go back to the founding days, there was no expectation that corporations would have any role in American democracy. Nil. Doesn't turn up in the constitutional debates. Doesn't turn up in the arguments leading up to the approval of the Constitution. It's only when corporations became big and powerful many decades later that they began to intrude in our politics, and they corrupted our politics in a terrible way, history shows. And that led to the movement by muckrakers, whose probably best leader was Teddy Roosevelt, to knock down the grasping political power of corporations and rein them in. And we had some real victories at that time, but ambitions of those of great wealth and power do not go away, and they have continually crept forward. It's an age-old story. And right now, we have corporate power controlling this Congress in a way that is really remarkable. We have a complete inability to address the climate havoc that fossil fuel emissions are creating because half of Congress has been disarmed and disabled by political influence of the fossil fuel industry. We can't even have a reasonable and sensible discussion on it because the power of that industry is so great. And we've seen that manifested first with Republican justices on the Supreme Court letting corporations into politics. That was an interesting invention. And then once they were in, they let them spend money in politics. And then once they let them spend money in politics, they let them spend unlimited money in politics. And now we are looking at a court whose majority is in the process of building a right for corporations, the biggest and most powerful corporations that we have, to not only get into politics, spend money in politics, and spend unlimited money in politics, but to spend unlimited money in politics anonymously, to hide from the real voters, the we the people, who they actually are when they're intervening in our politics, and to play this game through phony front groups with ridiculous names. Rhode Islanders for peace and puppies and prosperity, you know, sort of the quality of the name that's involved. So let's not get too excited about judicial philosophy if it's nothing more than a screen for a predisposition that will benefit certain players in the arena. And let's certainly not take judicial philosophy too seriously when it evaporates in the face of the interests that have pushed the philosophy. And I think originalism qualifies that way, and I just wanted to say that. I don't think you have to have a judicial philosophy. I think you have to have integrity. I think you have to have a judicial temperament. But a philosophy? Where has that come from? The second thing I want to say has to do with the question of court packing and the integrity of the court. And I have a position on this, and I just want to say it so it's all clear and nobody's reading things into it that I don't believe, and I've had a chance to make my point here. And that is that court packing can be done by adding new seats to the court. I haven't proposed that. I think there's only one member in the Senate that has proposed that. It's gotten a lot of attention here, but I don't think it's been proposed here. But you can also pack a court by picking the justices. And in fact, there is a long, unpleasant American tradition of agencies being taken over by virtue of picking the members. It's called agency capture or regulatory capture. It goes back a long way. There is an abundant literature, both in economics and in administrative law, about capture. And there's nothing that makes a court immune to capture. That is why when I talked about this in my initial remarks, I said that the folks that have tried to capture the court have treated it no different than a 19th century railroad commission, because they were legendary for having been captured by picking the members who would rule for the railroad. And there are many others. Go back to MMS in the Gulf oil explosion. So that is my concern. My concern is that the picking of the justices has been handed to special interests. And we know that's the case because, as I showed yesterday, everybody involved admitted it. The President of the United States said so. The co-founder of the Federalist Society said so. A former chairman of this committee said so. And the President's legal counsel said so. And what happened in that process by which the justices were picked over at the Federalist Society? We don't know. There wasn't a poll that was taken of Federalist Society members saying, give us your recommendations. I don't know that there was any meeting of the board. Let's take this up. Let's go through a proper agenda. What appears to have happened is that people went into a back room and there was wheeling and dealing, and millions of dark money dollars flowed into the Federalist Society during this period. And what came out were names. And those went straight to the president and straight to here. But the picking appears to have been done in the confines of a private organization by anonymous special interests. There is no country in the world that does that by way of how you pick judges. If we went to some banana republic to try to educate them in democracy, and that was the way they picked their judges, we'd have a lot to say about it. But that is the way that recent justices have been picked. Court packing by court picking. And deputizing this to the Federalist Society is very unusual. Them having no process, no public process for implementing that deputization is very unusual. The provenance of these mysterious lists that were produced and how people got on and off them, that is very unusual, unprecedented in our history. And it's surrounded by lots and lots of dark money. $400 million, I think, is a lot of anonymous money that has been chronicled being spent to control who gets put on the court. And controlling who gets put on a governmental body is how you capture a governmental body, and a captured governmental body is a wrong thing. Whether it's a railroad commission or the United States Supreme Court. There is in that method of judicial selection not just the prospect of impropriety, but indeed the likelihood of impropriety. If it's pay to play and checks for millions anonymously delivered will get you into the room to decide who is going to be on the Supreme Court, we got a problem. And that's what happened. And the thing that makes it even worse, in my view, is that as you pursue this and play it out, you see the decisions of the court line up in an astonishingly clear pattern with the interests of big Republican dark money donors. That is my concern. That, I think, is a legitimate concern. If you disagree with me, disagree with me. But that is the concern, and I wanted to lay it out here because it's not about court packing. It's about the integrity of the court, and it's about the unfortunate comparison that can be made now between the captured agencies delivered through picking of their membership and what looks more and more like a captured court delivered by the picking of its membership in secret with a very, very high ticket price to be in the room where the picking took place. So, like I said, colleagues can agree, colleagues can disagree. We all have our shots to make our cases. Because this has come up tangentially in multiple different ways, I wanted to take this moment and lay out what my case is and explain it as clearly and simply as I can. And I thank the chairman for allowing me that opportunity. And I yield back my remaining 7 minutes. And I congratulate, Your Honor, you for the patience that you've shown with all of us. It's not over, but it's close.
Thank you, Senator.
Thank you, Senator Whitehouse. And of course, you've joined the Hall of Fame, yielding back 7 minutes. Senator Lee.
Thank you, Mr. Chairman. Thank you, Judge. I want to talk next a little bit about a case that you were involved in, a case called Coal River Mountain Watch versus United States Department of the Interior. It was decided a ruling that you issued in 2015 while in the federal district court. I know you've handled a lot of cases.
I have.
I can't imagine that by merely triggering the case name that would necessarily bring it back. But this case involved a challenge to an administrative action within the Department of Interior on some issues bearing on coal mining within the state of West Virginia. There were two parallel challenges brought against that administrative action. One in a federal district court in West Virginia, where the land in question was located, and another in the U.S. District Court for the District of Columbia, where you sat. The government defending itself against that action brought by some environmental groups asked that you dismiss the D.C. case so that the matter could be litigated in West Virginia. You denied that. Can you, based on my description of the facts, does that ring any bells, and can you tell me why you might have denied it?
Thank you, Senator. It actually doesn't. It sounds like, dozens of cases that I handled with similar issues and requests. Yep. Something like a motion to dismiss is early in the action.
Sure.
And so denying a motion to dismiss is pretty routine. District of Columbia.
I understand, and I'm sure you handled a lot of those all the time as a district judge. The reason I raise it is just because it relates indirectly to some concerns that I've got that are somewhat unique to the Western United States. We have a lot of cases that involve the U.S. Department of the Interior and agency actions taken relative to the public land that we have. In every state east of Colorado, the federal government owns less than 15% of the land. In most of those, it's much less than 15%, in the single digits or low single digits. In every state, Colorado and west of Colorado, the federal government owns more than 15% of the land, and most of the time, it's a lot more. In my state, it happens to be about 2/3 of the land that's owned by the federal government. As a result, it complicates our ability to do just about everything we do, whether it's recreation, construction, oil and gas development, whether it's just accessing people's farms and ranches, or even something as simple as trying to fund local fire, police, search and rescue operations. All these things are affected by the excessive ownership of federal land by the federal government and the way it's often managed. Sometimes decisions made at the federal level are challenged in parallel actions like these. One in the forum state, in the host state to where the action is happening, another in D.C. And I'm always concerned about forum shopping. And I'm sure that's something you watched out for as a judge and saw forum shopping from time to time. It's also something that, touches on an issue that involves statutory interpretation. There's something called the Antiquities Act, passed 110 years ago or so, designed to give presidents of the United States the authority to designate parcels of federal land as national monuments. The text of the statute states that the limits of the parcels in question should be, quote, confined to the smallest area compatible with the proper care and management of the objects to be protected. Now, given that these presidential proclamations tend to be broad, it's sometimes the objects to be protected are also broad. And as a result of that, it's difficult to tell what the limits are. Do you have any reaction as to how we could discern that, how we could define any meaning out of that? It's got to mean something. The text of the statute, you try not to leave language simply unaddressed or meaningless in a statute. Do you have any thoughts on how a statute like that, saying that it should be confined to the smallest area compatible with the proper care and management of the objects to be protected? Any thoughts briefly on that?
Well, Senator, if I were presented with a case with that statute in that circumstance, I would proceed as I always have. You would have to understand the parties' arguments about the particulars in the case. What does the presidential proclamation say? To what does it relate? Whether there are any precedents in this area that further define or further address what Congress intended with respect to the statute at issue.
And I would assume that it would also matter if the government's lawyers defending the president's action made an argument that would leave the interpretation open-ended and meaningless.
Well, as part of your interpretive exercise, as you're considering the parties' various arguments, one that did not account for all the words in a statute would be one that you would
Excellent.
might
Excellent.
not might not agree with.
No, I get it. And this is one of the things that I've appreciated about what you've told us in these hearings. I really like the way you've described the fact it's important to construe the text that you're asked to interpret. And in interpreting that, you look at the language and you're endeavoring to figure out the original public meaning. And I think that is a very helpful thing. All right, let's move to a different issue a moment ago. Now, you clerked on the U.S. Supreme Court for Justice Breyer in October term 1999, is that right?
That is right.
That was the same, and you clerked for Justice Breyer.
I did.
And that was the same year that the Supreme Court issued its decision in a case called Stenberg versus Carhart. This is the case where the Supreme Court of the United States struck down a Nebraska law prohibiting partial birth abortion. In the absence of circumstances where the baby posed a threat to the life of the mother. Now, to be clear, the law prohibited a procedure where the abortionist causes an unborn baby to be partially delivered by the mother, and then the abortionist intentionally kills the baby outside the womb by puncturing its skull with scissors and then collapsing the skull. This is gruesome, and I don't like having to quote this, but it is relevant to the topic we're covering here. Justice Kennedy described it this way in chilling terms when in his dissent, when he describes the fact that when scissors are inserted into the back of the head, the fetus's body, wholly outside the woman's body and alive, reacts as though startled and then goes limp. Justice Scalia, in his great eloquence, lamented the ruling, but also expressed optimism for the fact that future courts would get it right, saying, quote, "I'm optimistic enough to believe that one day Stenberg versus Carhart will be assigned to its rightful place in the history of this court's jurisprudence beside Korematsu and Dred Scott. This method of killing a human child, one cannot even accurately say an entirely unborn human child, prescribed by this statute is so horrible that the most clinical description of it evokes a shudder of revulsion." We then saw a few years later the Supreme Court of the United States issue a different ruling. The Supreme Court issued a different ruling in a case called Gonzalez v. Carhart. Gonzalez v. Carhart upheld a different statute. This one was federal rather than state, but it was a different federal statute that also prohibited partial birth abortion. Judge Jackson, can you distinguish these cases for me? What was the difference between Gonzalez v. Carhart, where the partial birth abortion ban in question was upheld, whereas in Stenberg v. Carhart, it was invalidated?
Thank you, Senator. I don't have the opinions in front of me. I think it had to do with the method of extraction, the fact-finding related to the procedure. In one case, the district court had made some findings and the court felt bound by them. In another, there was considerations beyond those that were previously relied upon. So there were distinctions that the court looked at and considered in the cases, but yes.
Let's talk about court packing for a minute.
Yes.
One of the reasons court packing concerns me, one of the many reasons, is because it's not prohibited in the first instance. It's not prohibited by the Constitution. There's nothing in the Constitution that says that Congress may not change the size of the Supreme Court. There's no limitation on that. We have, for 152 years, stuck with the number 9. It has worked, and in the absence of an argument saying that that number is too low, that the court is too small, from a workforce standpoint, we need to expand it. it's difficult to imagine why it would be a good idea to change it, particularly because if you increase the size of the court in one fell swoop, and you do that for partisan political purposes, allowing one president, the current president, to have a disproportionate impact on the court and to change its rulings, that portion of the court's docket that tends to be more politically contentious. It can turn the court into a political football of sorts. Given the fact that our Supreme Court justices serve for life, once you do that, it becomes something of a one-way ratchet, always expanding, never contracting. Before long, you could see an increasingly larger court, with the court expanding each time a different party secures the coveted circumstance of a majority in the House, majority in the Senate, and controlled by the same party of the White House. And so this is why it concerns me. I understand that, why it is that the canons of judicial ethics don't allow you to comment on matters that might come before you. This is one that could not come before you as a justice. This is a non-justiciable political question. It's committed to the two political branches of government. There's not even a constitutional challenge that could lie to it, even though it would undermine the separation of powers in the Constitution, as I see it. It's not unconstitutional. So it couldn't and it would never come before you. Last night, when you were asked a question by my colleague, Senator Kennedy, on this, you acknowledged that you have an opinion. Did I understand that right? You have an opinion on court packing?
Senator, I have a lot of opinions. I have opinions on I'm a human being, and I have an opinion on a lot of things. The reason why, in my view, it is not appropriate for me to comment is because of my fidelity to the judicial role. I understand that it's a political question, and that is precisely why I think that I am uncomfortable speaking to it.
No, I understand that, and I respect the impulse. I respect the overall issue, and I think it's better for Article III judges and justices ordinarily to not wade into the political thicket. This one I do think is different because, number one, as I say, it can never come before you. Number two, it does have an impact on what you would be doing, and you also, as an Article III judge, someone who's served for nearly 9 years as a federal judge, you've developed experience and intuition and a thorough understanding of our federal court system, and that's why I think your perspective on it would be valuable. The reason it concerns me so much is that even when court packing doesn't succeed legislatively, it can leave an impact. The last time this was attempted was in 1937. President Franklin D. Roosevelt was upset at the Supreme Court on a number of bases. He didn't like the then 32-year-old precedent of Lochner versus New York, where the 5 conservatives on the Supreme Court engaged in an active judicial activism, reading something into the Constitution that wasn't really there. Some people disagree with me on this, but it wasn't there. And they imposed that. But the bigger reason was he didn't like the court's interpretation of the Commerce Clause. It was that interpretation of the Commerce Clause, the one we discussed yesterday, you know. Prior to 1937, you had the Supreme Court agreeing as far as the channels and instrumentalities of interstate commerce that we talked about yesterday. You had the court more or less in agreement over time as to the impact of the dormant Commerce Clause. But as to the substantial effects test, that didn't exist yet. It required something much closer to an interstate commercial transaction in order for Congress's Commerce Clause authority to kick in. There were the so-called 4 horsemen of the apocalypse, as FDR affectionately called them, 4 conservatives who were consistently pushing for limits on Congress's authority. And then you had other justices who would sometimes join with them. Usually that included Justice Owen Roberts, who had stood with them in maintaining narrower authority for Congress under the Commerce Clause. All that changed when on April 12, 1937, 2 weeks to the day when the case often associated with the so-called switch in time that changed 9, West Coast Hotel versus Parrish, where they undid the Lochner precedent. April 12, 1937, the Supreme Court decided a case, NLRB versus Jones and Laughlin Steel, that forever changed and magnified, expanded the Commerce Clause in a way that, had it been through a constitutional amendment, it would be among the most significant, impactful constitutional amendments ever adopted, and yet it's rarely discussed. This case resulted from one vote, one person on the Supreme Court who changed his vote, Associate Justice Owen Roberts. It's widely believed, and I believe it based on what I've researched on it, he was influenced heavily by FDR's court packing plan. He didn't want to be on a court that was packed. He didn't want, he convinced himself that he made that switch in order to save the court as it was. And that has changed everything. It's led to a much bigger, more expensive, more intrusive federal government. We can disagree as to the policy merits of that, but it did change the Constitution. That's why I worry about that. So I hope, I understand you don't want to answer it. I hope that between now and the end of the day, you'll see fit to tell us what your opinion is. I do think it's worth discussing. Let's talk for a minute. Got just moments left. I want to get back to your sentencing approach. Now, when you approach these child pornography cases, what you're describing in many circumstances is an overall concern that you've got with the sentencing guidelines, and particularly that portion of the sentencing guidelines that deals with child pornography cases. This showed up in the transcripts of some of your sentencing hearings, including the transcript of your sentencing hearing in the Hawkins case. I turn to that to page 38, lines 17 to 24 of that transcript, and here's something you say in that Hawkins case. And I believe this was the 18-year-old defendant that you sentenced to 3 months in prison, when the lower end of the guidelines range would have been 97. I think the higher end would have been in the 120s or something like that. You said, and in your case, this is you speaking to Mr. Hawkins, in your case in particular, I don't feel that it is appropriate necessarily to increase the penalty on the basis of your use of a computer or the number of images or prepubescent victims, as the guidelines require, because these circumstances exist in many cases, if not most, and don't signal an especially heinous or egregious child pornography offense. I've got a couple of questions about that. Were those, you start out that paragraph sounding like you're making a determination as to him, but then the observations you make in that paragraph seem to apply broadly. Is that right? So
Senator, I don't have the transcript of Mr. Hawkins' case. I recall that I found that case, like all child pornography cases, to be difficult, really difficult. And his case, I recall, was in many ways an outlier in terms of the various considerations that Congress required me to take into account.
But there were prepubescent victims that were at stake in that.
I don't remember how many. I don't remember the circumstances of his actual crime. What I will say is that, consistent with Supreme Court case law and Congress's statute in this area, judges have to take into account a number of factors, and the guidelines, which are no longer, I won't say not mandatory, you have to calculate the guidelines, they're no longer binding. And the Supreme Court has said that under the statutory scheme, judges have discretion.
But I'm almost out of time.
Yes.
Here. I want to make the point.
Yes.
Hawkins, as I recall, and as Senator Hawley discussed yesterday, he specifically asked for images of 11 to 17-year-olds. So I don't understand how that can be an instance where that shouldn't matter, and where the fact that he did it with the computer hardly atones for what he was doing, hardly offsets the fact that he was seeking and obtained prepubescent child pornography images, nor does the fact that the images become easier over time to transmit and receive and store because of computers, I actually think it cuts in precisely the opposite direction that you described. It makes it more severe, not less. I see this as an aggravating factor, and that is of great concern to me. I see I've exceeded my time. Thank you.
You may respond.
Senator, as in every child pornography case that I sentenced, I considered all of the evidence, all of the relevant factors. It is not the same exercise to look at a transcript, to think about guidelines, to not have in front of you the individuals, the victims, the pictures, the circumstances that trial judges have to review in these cases or any cases. I understand, Senator, that there are some questions about records, et cetera. Courts have all of the evidence, and courts have all of the recommendations of various parties, and courts have, under Congress's authority, the responsibility of using our judgment to make determinations that are sufficient but not greater than necessary to comply with the purposes or promote the purposes of punishment, taking into account things like unwarranted sentencing disparities. And it may seem like an easy exercise. It may seem in retrospect, when you look back at a few pieces of data, that courts have not done what it is that they are supposed to do. But what I can assure you is that I took every one of these cases seriously in my duty and responsibility as a judge, and I made my determinations in light of the seriousness of the offense, the nature and circumstances of the offense, the history and characteristics of the defendant, the need for the sentence imposed to promote various purposes of punishment, and all of the other factors that Congress prescribes.
Okay, but you keep resetting that standard, and yet you specifically excluded from consideration the fact that he had requested and obtained images, prepubescent child pornography images.
Senator, I didn't exclude it. I didn't exclude it. What I did was I looked at the guidelines, which is what the Supreme Court requires, and I was making policy determinations as the Supreme Court says that judges are to do.
Look at
in
page
these
38
situations.
of your transcript. It looks to me like you excluded it, and your action sentencing him to 3 months for one of the most heinous offenses imaginable. Keep in mind, because these are transmitted
Senator,
electronically, they're there for years. They re-victimize these victims the rest of their lives.
We're asking everyone to try to stick with the 20 minutes, please. Next is Senator Klobuchar, but before recognizing her, I'd like to ask consent to enter into the record a support letter for Judge Jackson from 48 former federal prosecutors in South Florida. Without objection, Senator Klobuchar.
Thank you very much, Chairman Durbin. Welcome back, Judge Jackson. Yesterday, you and I discussed the court's increasing reliance on issuing unsigned orders on its shadow docket. And less than an hour ago, the court once again used the shadow docket to throw out Wisconsin's redistricting maps. And because this decision just came out, I don't expect you to have immediately reviewed it. But I just want to make this point that in her dissent, Justice Sotomayor, joined by Justice Kagan, called the court's move unprecedented. She noted that in an emergency posture, the court summarily overturns a Wisconsin Supreme Court decision resolving a conflict over the state's redistricting, a decision that was rendered after a 5-month process involving all interested stakeholders, based on an obligation that is, these are her words, hazy at best, even though summary reversals are generally reserved for decisions in violation of settled law. And again, I don't expect you to be familiar with this case, but I do want to point out that this underscores the point that I made yesterday, that the court's increasing practice of using the shadow docket to decide cases that have grave consequences for our democracy, including the right to vote, that you and many other nominees have said is fundamental, is incredibly troubling. You had in the other case I mentioned yesterday where Justice Roberts dissented, the Texas abortion bounty hunter case, that should not have been done on the shadow docket. And while I'm not going to ask you about this because you couldn't possibly have read it, just your record of writing decisions that are thorough and listening to litigants in cases, could you just generally talk about the importance of having full briefings on the merits as well as public oral arguments if you believe in transparency?
Thank you, Senator. As a judge in my work over the last decade, I've seen that it is very important, at least to me in my time as a judge up to date, to hear arguments from all sides in a case. The duty of a judge is to make determinations, and under our system of adversarial proceedings, you make determinations based on arguments, and it's important to do so. I know that with respect to the emergency docket, you haven't asked me the question about it, because I would say what I said before, which is I would benefit from being able to speak with the justices. I understand that there's a need to balance getting full briefing with emergency circumstances, and the court has long had in its procedures the ability to rule quickly on various cases. Mm-hmm. It's also my understanding from my time clerking on the court that the court does recognize the value of allowing things to what we call percolate, meaning lower courts to hear issues. And my understanding is that at least in some of the recent cases, the justices have had an oral argument related to some emergency matters. But from my perspective as a judge in the work that I've been doing, I know that it's important to hear from the parties.
Mm-hmm. Another hallmark of your work has been taking complex issues and making them accessible to the public. So much so that I actually referred to one of your opinions from a debate stage in Los Angeles, saying, as a wise judge said, those were my words, I guess I was ahead of my time, the president is not king in America, the law is king. I paraphrased it. That was a written opinion that you wrote that was over 65 pages long, relied extensively on Supreme Court and circuit precedent. It was Committee on the Judiciary v. McGahn. And could you talk about really two things, the importance of having the law written in terms that are easy to understand by people, and then secondly, your opinion was actually a narrow one. It required Mr. McGahn to appear to testify, but that said he remained free to assert any legally applicable privilege in response to the questions asked. So what you did there was a narrow opinion. What role do you think that narrow rulings play in helping to maintain the legitimacy of the court? Why is it important to have plain language in orders?
Thank you, Senator. Well, I'll start with the second first. Mm-hmm. I think that, as we've been discussing, we have a rule of law in this country which requires a certain amount of predictability and stability in the law. If there are big shifts in terms of legal principles and doctrines and whatnot, it could lead to people not understanding that judges are ruling on legal principles. It could lead to undermining public confidence, thinking that judges are injecting their own policy preferences rather than following the law in terms of their rulings. And so to further predictability, stability, there are many doctrines in judicial practice. There's stare decisis, which is the principle that if something has already been decided, very similarly, you at least if it may be binding on you if you're a lower court, but at least you have to contend with it because that is the law that existed before you got the case, and you don't want to make a big shift. And then there's also the principle that the understanding that when you are announcing rulings, you are building on what exists before. And so you don't want to make a big shift if you don't have to, because if you can find a way to rule incrementally in a more narrow way, it keeps the law stable as a part of the proposition that I mentioned before. In McGahn in particular, it was a case in which there was a precedent directly on point from my district. It was not binding on me, but the exact same set of circumstances and arguments had been presented to another judge in my district. I believe it was something like 10 years prior to my case. And so we had law that governed the circumstance, and I looked at that, determined it was persuasive, and that I should continue the principles that had been laid down in the prior case. Also, in accordance with those principles, the prior judge and I made the determination that when the president claims absolute immunity, the argument was that the person who had been subpoenaed by the legislature, a former employee of the White House, could say that they had immunity of some sort. In other words, it could have invoke executive privilege in response to particular questions, but they couldn't say, I don't have to show up at all. And so the argument that was being made was when the House of Representatives issues a subpoena and says, show up on this day at this time to answer questions, can that person just ignore and say, I have immunity, I don't have to follow the law, in other words, respond to the subpoena? Or do I have to show up and sit there and listen to the questions? And if there are things that I believe I can't answer because they're privileged, then you invoke the privilege. Mm-hmm. And the prior case had said in this narrow way, you have to show up. You don't necessarily have to give the information. That's determined on a question-by-question basis, but you have to show up. Mm-hmm. And that's what I held in that case as well. And it's important to be clear in your rulings so that people understand that judges are ruling consistent with the law and not their own personal views.
Right. And speaking of being clear and being careful in your rulings, some of my colleagues have, I think, given not a necessarily true view of your whole record, because when it comes to your rulings being upheld, the numbers show that out of over 550 cases, your district court cases, you were reversed less than 3% of the time. And in some of the instances, you were reversed only to have your decision later upheld. I noticed one case, Territory of Guam v. United States, in which you were initially reversed, but then a unanimous Supreme Court reversed that decision, then siding with you in an opinion written by Justice Thomas and aligned with your view. Do you want to quickly talk about that case?
Well, that case is kind of legally complicated. It was a CERCLA case, which is a Superfund cleanup kind of case where the country of Guam, which has a dump site on it that was used by both the citizens of Guam and the United States before the 1950s, when the United States was stationed there, military operations happened out of Guam, and there was a lot of dumping into this site. And over time, the site got contaminated, and Guam was charged with having to clean it up, which is millions and millions of dollars. And there are statutes, very complicated statutes, about the circumstances under which you can seek contribution, under which a country like that can ask for the United States to pay some of that cost, or other countries to pay some of that cost. And that was sort of the nature of the dispute. And I did a statutory interpretation about whether or not Guam's action could proceed. The United States filed a motion to dismiss, saying that all of the technical requirements of the law weren't met and that the action had to be dismissed. And I denied the motion to dismiss after interpreting the statute, saying that the action could continue. The D.C. Circuit reversed my view, had a different reading of the statute, saying that the motion to dismiss should have been granted, and dismissed the case. And then it was appealed to the Supreme Court. And as you say, the Supreme Court reinstated the action, saying it could proceed.
Very good. Thank you. In 1972, in Brandsburg v. Hayes, a 5-4 court did not recognize the reporter's privilege in the context of criminal grand jury testimony. I spoke with you earlier at length about Times v. Sullivan and First Amendment issues, so this will be my last question on this. Since the court's decision, my state, like many other states, enacted strong reporters' privilege laws to protect journalists from having to divulge unpublished materials, confidential sources. How would you approach balancing the need to protect journalists and the role they play in informing the public against the need for law enforcement officers to gather information?
I would apply the precedents of the Supreme Court in this area. It would depend on the circumstances. As I mentioned, press freedoms is one of the fundamental First Amendment rights. The court has a number of precedents in terms of expressive freedom, press freedom, and in every case, there'll be a specific set of circumstances regarding an alleged violation of the right, and the court would need to look at the facts and circumstances, the prior precedent, in order to determine whether that particular regulation could be upheld.
Okay, thank you. This is my very last question, Chair, before all of us get to eat lunch, including you. And that is really the important role of dissenting opinions. Justice Ginsburg once said this. She said, "Dissents speak to a future age. It's not simply to say my colleagues are wrong and I would do it this way, but the greatest dissents do become court opinions, and gradually over time their views sometimes become the dominant view." When Justice Ginsburg's rabbi gave a eulogy at her memorial service here in the Capitol, and some of us were fortunate enough to be there. He said, "Justice Ginsburg's dissents were not cries of defeat. They were blueprints for the future." What do you think is the purpose of a dissent? And do you want to talk just a little bit about that, this idea that they can be blueprints for the future?
Thank you, Senator. On the Supreme Court, there are 9 justices, and in every case, they're all sitting together to hear the issues in a case. And one hopes, and it often happens, that the justices agree as to issues in cases. That I believe that the vast majority of cases that the justices hear are actually not, there is no dissent, that they agree to the outcome. But there are cases in which, after deliberation and collaboration and consideration, the justices may disagree about how the case should be resolved, and there's a mechanism for every justice to decide whether they're going to join others, either in the majority, whether they're going to write a separate opinion that might agree with the majority but wants to make a different point, or whether they want to dissent. And sometimes more than one justice might dissent or join a dissent. It's a way of expressing one's own view that may differ from your colleagues. And with respect to the point that you made, there are actually many justices in history who have used the dissent mechanism to discuss the law in ways that others find over time to be more persuasive. And so I'm thinking of the first Justice Harlan, who dissented famously in Plessy versus Ferguson. He dissented alone. All of the other justices agreed with the proposition of separate but equal, and he said no in a dissent. And his dissent, generations later, became, according to Justice Thurgood Marshall, became the blueprint for Justice Marshall to make arguments that led to Brown versus the board. So there is the opportunity for justices to describe their views in ways that become persuasive to others in the future.
Thank you for all you've given us the last few days. We look forward to working with you. Thank you.
Thanks, Senator Klobuchar. And we're going to break now for a 30-minute lunch. I'd say to everyone that when we return, if we stick to 20-minute rounds and don't yield back time, we'll be finishing in something around 4.5 hours, which would take us to about 7 o'clock. So that doesn't include a break, but we'll consider that later on. Thank you, Judge, again.
All right, you've been listening to day 3 of the confirmation hearings for Judge Ketanji Brown Jackson. Today's the final day for Judge Jackson to defend her record and her judicial philosophy. She's been pressed on a range of issues, from her judicial philosophy, the separation of powers, and whether a president is above the law. She's also been asked about abortion and expanding the Supreme Court, as well as criminal sentencing. And we have seen some heated moments, including during questioning that Jackson got by Senator Lindsey Graham. Let's listen to that.
So in a world in which the mail is used for the purpose of distribution, it really matters whether the person has distributed 1 or 5 or 1,000. And so the guideline says, you know what? We are going to treat a person who's distributed 1,000 a lot worse, because that shows that this person is really engaged in this really horrible behavior. In comes the internet. On the internet, with one click, you can receive, you can distribute tens of thousands. You can be doing this for 15 minutes, and all of a sudden, you are looking at 30, 40, 50 years in prison.
Good. Good.
I understand.
Absolutely
Senator,
good. I hope you are.
To do.
Good.
Allow her to finish, please.
I hope you go to jail for 50 years if you're on the internet trolling for images of children and sexual exploitation. So you don't think that's a bad thing? I think that's a horrible thing.
That's not what the witness said, and she should be allowed to answer this question once and for all. Senator,
all I'm trying to explain is that our sentencing system, the system that Congress has created, the system that the Sentencing Commission is the steward of, is a rational one. It's a system that is designed to help judges do justice in these terrible circumstances by eliminating unwarranted disparities, by ensuring that the most serious defendants get the longest periods of time. And when modes of commission of the crime change, such that in 2 seconds, someone can receive or distribute thousands of images, that's no longer and this is what the commission found in their studies, an indicator of a person who, relative to other people, has committed this crime in a more aggravated way.
That was just part of a much larger interaction between Senator Lindsey Graham and Judge Jackson. A lot of interruptions there as Judge Jackson tried to explain some sentencing rulings that she had made in child pornography cases. I want to bring in senior Washington reporter Devin Dwyer, who's there in the hearing room, ABC political reporter Brittany Shepard, and ABC News contributor, legal analyst Kate Shaw, who's here with me on set. And Devin, I'd like to start with you because as you predicted, they got a little tense at times, particularly during that line of questioning by Graham. What's it like there in the room?
Well, first, Diane, you've got to observe night and day performance by Judge Jackson. And in the clip you just played, what an extraordinary display of pushback. She is animated. She is engaged. She is emotive. She is really, engaging with these senators today in a way that yesterday, much more reserved, cool, calm, collected. It's night and day. One of her former clerks texted me and said, this is the real Ketanji that you're starting to see today. So clearly more confidence from the judge today as she pushed back. I'll also say that exchange, again, trying to lay out the context and nuance of sentencing. The country is getting quite the education the past few days in what goes into judicial sentencing. And, while Senator Graham certainly is allowed and is raising legitimate questions and concerns about her record, there are also some inconsistencies. He's being a bit disingenuous, cutting her off, not allowing her to explain the factors that Congress has in fact required judges to take a look at, and not addressing the inconsistencies himself. I mean, I was just taking a look, Diane, Lindsey Graham has supported 6 federal judges just in the past few years, appointed to the federal bench, promoted to the federal appeals court, who also delivered sentences in child porn cases below the federal guidelines and below what the government requested. His office just got back to me and said that for Judge Jackson, this is sort of a new job and a new standard, and therefore he believes that she should be held to that higher standard. Certainly a reasonable approach, but no explanation as to why it would be endangering children, and, as he was implying here in what she did, but not endangering children with these numerous other judges that he and other Republicans on the committee have supported. So we're seeing a continuation of that prosecution, but as a lot of members on his side of the aisle have said already, it really rings hollow.
And, the stakes obviously are higher here than on previous confirmation processes and hearings. But with these hearings, there always does come a bit of political theater. And we know a lot of these senators are going to be understandably trying to score some political points. But, Brittany, when you see this kind of exchange of a lot of interruptions, and especially given that Brown did keep her composure, she didn't really lose her cool, could this kind of a strategy backfire for Graham or anybody else who tries to be a bit more forceful and tries to do a lot of interrupting like we just saw?
Well, there are certainly Democrats who are taking to Twitter who believe that Lindsey Graham is trying to poke the bear and get under Ketanji Brown Jackson's skin. Like Devin said, this is not the Ketanji Brown Jackson we saw on Monday and Tuesday. This is one who's willing to fight back, push back on inaccuracies, but you see she's getting flustered. She's sighing, she's making faces. Clearly, this provocation is getting under her skin, and Republicans run the risk of getting stereotyped as someone who's trying to further a narrative of the angry black woman. We heard this when Republicans were trying to write now Vice President Kamala Harris or Stacey Abrams as unwieldy, as someone unable to answer questions during debates or unable to pin down reporter questions. And Democrats are already angry. They're already sharpening their knives. They're already taking to Twitter saying that Lindsey Graham is being inappropriate in his questioning, and whether intentional or not, he is painting this narrative and might be building to a narrative to try to get under Ketanji Brown Jackson's skin. So there is a made-for-TV moment, something like in the Kavanaugh hearing where they're screaming or crying, or at least for Ketanji Brown Jackson making a face to say, I can't handle this anymore. That's something the Republicans are looking for their made-to-TV moment. And it, like I said earlier, runs the risk of being painted as like playing towards racist tropes, which the Republicans do not want to get their hands stuck in that cookie jar.
And Kate, in terms of the legal arguments here, Graham is trying to show that Jackson is soft on crime, or trying to argue that at least, especially in relation to these child pornography sentences. And then we have Jackson, who seems to be arguing that she was applying these sentences in a way, or the guidelines at least, in the way that they were intended. So walk us through these legal arguments and why this continues to come up.
Sure. And I will say, I do think that she was more animated in that exchange with Graham and several others today, but but I'm not sure we're seeing her flustered so much as really determined to communicate what she understood her task to be and her role as a judge to be. Look, she's a criminal justice expert and a sentencing expert in particular, right? Well before she was a federal judge, she was a staffer on the Sentencing Commission. She was a federal defender representing people facing charges and sentencings. Then she was a commissioner on the Sentencing Commission, and now, nearly a decade as a federal judge. So she knows sentencing inside and out. And I don't think she's going to just sit quietly while she's challenged in terms of her kind of bona fides on federal sentencing. She knows this world is a policy matter, and she has done it time and time again. So what she's explaining with respect to the child pornography cases, including the one that Graham was asking about, is that there's simply something quite outdated in the way the sentencing guidelines treat volume or quantity of child pornography materials, because they were drafted in a pre-internet age in which it was wildly more serious to have, 100 or 1,000 pieces of material versus just a few. And so the severity of the sentence was dramatically different as between, offender 1 and offender 2 based on quantity. And her point is that in an internet age in which in 1 second you can download enormous quantities of material, there's nothing to suggest that's not serious, but that doesn't distinguish the seriousness of that offender from another offender who may have less material but more serious other aggravating factors. And so her explanation is we can't just look at quantity. And I think she was very firm in that position. And the explanation, and again, situating that in the context of a regime in which Congress has said federal district judges must exercise discretion, take a lot of factors into account, and render the sentence that will do justice and not promote unwarranted disparities. And I think she very much has been defending the fact that that's what she did in each and every case.
Devin, we've also heard Graham focus on a case surrounding the role of the federal government in immigration cases. What's the background on that case? We keep hearing Lindsey Graham and others mentioning sole discretion, the fact that that was written in as part of the law. Why are we hearing so much about this case? What's the background there?
It was a high-profile case. It was called Make the Road versus DHS, the DHS secretary at the time, and it's a Trump administration case, Diane, that was reversed. Her opinion in the case was reversed by the D.C. Circuit. So we heard Lindsey Graham calling out the fact that she was overruled, and it did deal with the expedited removal of undocumented immigrants in this country. And you saw him bring out the poster board, bring out the text of the law, which he said Congress made very clear, and there you see it, that the government has the decision and discretion to expedite the removal that shall not be questioned. But what she reasoned, she stood up for her decision here, was that the way the Trump administration did this under the Administrative Procedures Act, which sets out the guidelines for how the government can change its policies, was not appropriate. And so she reasoned that the appeals court reversed her, said, no, actually the law is very, very clear. And so there was a bit of a tangle there. She stood for her view, but there was really no hiding the fact that she was overturned, but she owned it.
And Brittany, Lindsey Graham, for all his fireworks, he's not only supported Judge Jackson's confirmation in the past, he also voted to confirm Justices Sotomayor and Kagan, both Obama nominees. So does it seem like Judge Jackson can get not Graham support specifically, but Republican support in general? And if so, who do you think seems most likely to vote in her favor?
Well, the environment inside the chamber and outside the chamber, like you said, is a little bit different. I think it's a foregone conclusion to think Lindsey Graham is going to be following up on his support of Ketanji Brown Jackson. But if you asked me maybe 2 hours ago, it seemed that John Cornyn was open to maybe supporting Ketanji Brown Jackson. This is actually an office, a place to work, so folks are leaving to make votes, surprise, surprise. And reporters are able to catch John Cornyn in the hallways, and he still said that he is not written out supporting KBJ at the end of this week, but is skeptical on some child porn sentencing, and especially this issue of court packing. We're hearing court packing, court packing, court packing. It's the sound clip of the day. And Republicans have been pushing Ketanji Brown Jackson to firm up her opinion, and it doesn't seem like something that Ketanji Brown Jackson is willing to give her opinion on record, and she has been mounting a pretty good defense of why. Outside the chamber, there seems to be some movement. Susan Collins was able to catch up with our Rachel Scott earlier this morning and said that she's keeping an open mind, which is one of 3 possible grab bag Republicans for the White House and for Democrats to get in their big bipartisan headline. Still not much movement from Mitt Romney and Murkowski. I'm curious to see how they'll characterize their view of the hearings later on this evening.
And Kate, Judge Jackson is also pressed on abortion quite a bit. Roe v. Wade could be in the crosshairs of the Supreme Court soon. Do you feel like you've gleaned anything from her answers and from previous decisions?
So she's been very careful in her answers, hasn't really touched anything too closely related to abortion or Roe versus Wade. Look, the court is right now considering a case out of Mississippi that, will, I think, very likely involve the court either functionally or formally overruling Roe. So, it's not abstract. It's coming, I think, down the pike very soon. So there'll be also questions about, in a post-Roe era, what kinds of restrictions states can impose maybe on things like travel out of state to obtain abortion. So this is all something that will very much be before her if she is confirmed and on the court by next fall. She was asked, Mike Lee asked her to distinguish between 2 previous Supreme Court cases on partial birth abortion, one a state case the court struck down, and then, or state law the court struck down, and then a federal law the court upheld. Lee asked her what was the difference between those 2 laws, and she sort of identified some potential differences in lower court findings. But actually the truth of the matter is what changed between those 2 cases was the composition of the Supreme Court, right? Different justices have voted in different ways about what the Constitution protects in terms of a right to autonomy and a right to control reproductive decision-making. Right now we do have a quite conservative court that seems really skeptical of Roe versus Wade. So I think that, there's every reason to believe that she supports, the holding of Roe versus Wade, and that she has said many times today and yesterday that she believes in stare decisis, that the court should adhere to its prior decisions. And yet I think she was, for good reason, extraordinarily careful about saying anything too definitive about abortion and the Constitution, and given sort of norms about talking about things that are so clearly currently before the court and likely to come again before the court, I think she was right to steer clear.
And now, Brittany, there's always a level of political theater during these hearings. Do you feel like you've gleaned any political insights from some of the questions asked so far, particularly from potential presidential hopefuls in 2024?
I think we saw a lot of that political theater play out yesterday with Tom Cotton, Ted Cruz, and Josh Hawley. And what I've gleaned so far is that the road to a potential presidential nominee, if you're a Republican, is in the trenches of what we like to call the culture war and what Republicans have been mounting for the past few months. I was at CPAC in Orlando. It feels like a long time ago. It was just a few weeks ago. Senator Cruz was there making similar arguments against this boogeyman of critical race theory, not talking about it in its practical applications in the legal field or its study of it in law school or in upper education, but how it might impact Republican voters' children. And then you saw a similar question posed to Ketanji Brown Jackson by Ted Cruz just yesterday, and I quote, "Do you believe babies are racist?" End quote. It's a soundbite I think is to be heard around the world this week. And of course, that kind of question doesn't fall within Judge Brown Jackson's purview and probably will not if she sits on the Supreme Court. But it plays well with voters. It plays well in state houses where voters are worried and parents are worried about this boogeyman that they don't really know about, that they're not really encountering, and that teachers are having to fight day in and day out as they're being removed from school boards in places like Texas, in places like Florida. And that's also why I think you saw someone like Tom Cotton be so firm about crime and capital punishment. He knows that Ketanji Brown Jackson can't answer those kinds of leading questions of whether there should be more or less people in prison. In fact, I believe if she answered any of those kinds of questions, he would be outraged and he would be tweeting about it and his office would be flaming her up and down, as with the RNC. But it's a good posture to take to show that you, as a Republican, was tough on Biden's so-called progressive nominee. And I suspect we're going to see more of that today. Ted Cruz, I believe, is either next up or one of the next few senators to speak as folks come back from lunch. And I'm curious if he does things like he did in the intro, like plug his podcast. And if you're a voter turning in today, you're going to get confused with all this legalese. And so I think you're going to see more of that coming on today.
They have the spotlight, and they know it. Devin, on that note, there was also another testy exchange with Senator John Cornyn, who appeared to try to pin Judge Jackson down on whether or not she called former President George W. Bush a war criminal in an argument for one of her past cases. Let's listen to that moment.
Let me just ask you one question. When you accuse somebody of a crime, are you calling them a criminal?
Oh, Senator, I haven't accused anybody of a crime.
That's not my question. When in common understanding and in plain English, if you accuse someone of a crime, are you accusing them of being a criminal?
It depends on the context. It depends on what else you say about them. It depends on the circumstances.
It depends on the circumstances.
Yes.
So you put this in the same category as defining what a biological woman is?
No,
You're really not sure.
I didn't say I wasn't sure. I said it depends on the circumstances.
So you are sure?
No, I said it depends on the circumstances that you're positing as to whether or not you're calling someone a criminal.
Devin, this exchange went in a lot of different directions. So can you put this into context for us? What are both Jackson and Cornyn trying to argue here?
This is a follow-up point from an exchange the two of them had yesterday, although Senator Cornyn today not directly mentioning it here. He was trying to be a little cute by coming at Judge Jackson sort of out of left field on this one. But this is a dispute both of them argued about yesterday. Remember, Judge Jackson was a federal public defender for a time. She represented some Guantanamo Bay detainees, also in private practice. And in one of those briefs she filed on behalf of the detainees, she made arguments on behalf of her client at the U.S. Supreme Court, alleging that one of the reasons why her client should be given a hearing was that he was being mistreated in U.S. custody, and she wrote in the brief that those sorts of behaviors would amount to a war crime, would amount to torture, and so yesterday we saw John Cornyn accuse her with that writing of calling George W. Bush and Donald Rumsfeld war criminals. She said she didn't use those direct words, and today he was trying to connect those dots and say, well, if you were writing in your brief that there was a crime committed, isn't that effectively calling someone a crime? She didn't bite. She did a pretty good job dancing around that, Diane, but that's what that was all about.
All right, Devin Dwyer, Brittany Shepard, Kate Shaw, thank you all. And ABC News Live will have more continuing coverage of the Ketanji Brown Jackson confirmation hearings, as well as some of the day's other top stories right after this break. Stay with us. Welcome back. President Biden is heading to Brussels today to meet with NATO allies, and on his way out, he reiterated that Russia's potential use of chemical weapons in Ukraine is, quote, a real threat. And there he is boarding right after leaving the White House today. Secretary of State Antony Blinken announced that the State Department has made a formal assessment that Russian forces did commit war crimes in Ukraine. Senior national correspondent Terry Moran is traveling with the president. He joins me now from Brussels, where the president is due to arrive very shortly. Terry, what does this announcement mean about Russia did, in fact, commit war crimes?
Well, it's the formal finding of the American government, Diane, after the president had said that in his personal opinion, he thinks Putin is a war criminal and that war crimes are being committed. I think everyone around the world, just looking at the video, all those shells and missiles slamming into apartment buildings and schools and hospitals, those are war crimes. There are other war crimes that may be going on down on the ground with people who are being detained, abducted, perhaps even transshipped to Russia against their will, their passports taken away. What this substantively means is it starts the gears going, the wheels running on an American investigation, which would come in support of, to some degree, with the International Criminal Court. The United States is not a member. The United States can bring its own resources to what is going to be a massive investigation. Now, it's important to remember, having covered a bunch of war crimes trials in the past, that unless Russia somehow loses, it will be a statement about the criminal conduct of Russia, if in fact the evidence shows that, as it seems to, and it'll be hard to get at the individuals. It'll restrict their movements around the world. Perhaps President Putin won't be able to go many places, but all that is in the future. What this does, this announcement that the State Department believes that Russian forces have committed war crimes, is it gets American investigations going that can support what also might be a Ukrainian investigation into crimes committed on their soil.
And Terry, Biden is expected to meet with NATO and European allies before he then heads to Poland to address the refugee crisis. A top national security aide says he plans to announce some new sanctions against Russia this week. What do we know?
Well, these are additional sanctions. Russia has been sanctioned more than any country, any major economy, certainly, in history. There are some loopholes, though. Unfortunately, these sanctions that are being announced by the president, probably when he gets here tonight, won't close the major loophole, which is that energy money. Russia's still getting billions of dollars and euros from people for selling its gas and oil. What will happen today is the United States is going to sanction members of the Russian legislature, hundreds of them, the lower house, the Duma it's called. They will be sanctioned, and that's new as well. Once again, trying to tighten the screws, not just on Russia, but on the Russian ruling class, as it were, to try to get some pressure that would persuade them to stop this war. But right now, Putin clearly pushed all his chips into the center of the table, and there's no indication that sanctions or no sanctions, war criminal designation or not, he's going to stop.
And the White House also says that the first deliveries from the $800 million in new military assistance Biden authorized for Ukraine has started to arrive. What's the latest on how that's going?
Well, that is a major contribution by the United States to the Ukrainian Defense Forces. Look, they need it, obviously. They are outmanned and supposedly outgunned, and yet because they are more nimble, more opportunistic, better disciplined, and perhaps more motivated, they have, at the very least, stalemated Russia on the battlefield, if not actually in some places taking back ground as well. So this $800 billion American aid, military aid, from Stinger missiles to more Javelin anti-tank weapons to all kinds of ammunition and small arms to keep that force primed and ready to go on the attack, because you can't really win on defense. That's going to be absolutely critical for the Ukrainian forces. Right now, as I say, this is clearly a stalemate. Russia came in with all of its forces, and they are barely gaining ground, losing ground in some places. And so the United States wants to make sure that the Ukrainian forces have absolutely everything they need. They are still asking for planes. Their Air Force has done remarkable in the skies, more than a fraction of what the Russians have in terms of plane. They haven't lost as many, but they want more planes. So far, NATO has not provided that. That is going to be a big ask that President Zelensky has. However, the major thing that President Zelensky has asked for, which is a no-fly zone over Ukraine, that is still not on the table, according to the White House and other NATO allies. They just think it's too risky. It would involve the United States and NATO allies in direct confrontations with Russia, risking a war with Russia, and that is something that the president has said he will not do.
All right, Terry Moran in Brussels for us. Terry, thank you. And here at home in Washington, D.C., it is day 3 now of the Supreme Court confirmation hearings for Judge Ketanji Brown Jackson. This is her final day to defend her judicial philosophy as well as her record as a judge, as she's questioned by the Senate Judiciary Committee. I want to bring in Republican strategist Antonia Ferrier and Democratic strategist Xochitl Hinojosa now for more on that. Antonia, where do you think Republicans have been most effective in terms of trying to show areas of concern about Judge Jackson?
There's no question when they keep coming back to something, and that's on child pornography and her decisions on sentencing, that is clearly an area where they think there is opportunity there. And that's why they keep coming back to it. I also think there were some very interesting lines of questioning that may not make some headlines, but the question that I think that John Cornyn was trying to get to was, did she put her own personal views, did they cloud her judgment? And I think that is what they're trying to get at, both with child pornography, which is obviously abhorrent, and also with what Senator Cornyn was doing, trying to get to whether or not she put her own views ahead of that of the law. And so I think they were both effective.
Xochitl, where do you think Judge Jackson has done particularly well so far? Xochitl, I think you're on mute.
I don't think she's taken the bait on any of the Republican questions. And I think that that is critical for any confirmation hearing. She has been very diligent about talking about exactly how she approached every case and her judicial philosophy moving forward. She's talked about how she hears both sides. She talks a lot about practice and ensuring that there is consistency. She's talked a lot about precedent. So there have been a number of instances where Republicans have tried to trip her up or have tried to get under her skin, and that doesn't happen. And so I think she's doing an amazing job. If anything, she has shown that she is qualified to the American people and to the full panel of the Senate Judiciary.
And Antonia, one of those senators, of course, trying to get under Judge Jackson's skin was Lindsey Graham. They had a whole exchange where he continuously interrupted her. What's the strategy there? Do you think it's a good one, or could that backfire on Graham and any other senator who tries it?
Look, she is a professional woman. She's highly educated. She's professional. She's well accomplished. She can't take the heat here in a difficult line of questioning, then I'm sorry, that questions her qualifications to a certain extent. She's prepared for this. They prepped her for this. So I think what he tried to do was clearly rattle her and see what would happen. She kept her cool, but, Senator Graham knows how to try and push buttons and play to the crowd. He's been doing this for a long time. I think he scored some points there, and I think he got some made-for-TV moments. There have been a lot of commentary about how this is a political theater. It is. This is political. These are politicians. They are elected. And, her questions and her answers over child pornography, I would not be surprised to see them being used in the fall by Republicans. Whether it's right or wrong, or you don't like it or not, that's just what I expect to see.
And Xochitl, how much of this is not just about scoring political points, but also trying to set a precedent for what is expected of future Supreme Court nominees to answer? Because you do frequently hear the previous nominee answered a question about this and that and the other. So how much of this is trying to establish some kind of precedent?
Well, I think it's interesting that Republicans continue to try to distract and bring up Justice Kavanaugh and Justice Amy Coney Barrett. I think the interesting part of this is that because they don't have anything to really highlight in terms of and hit back on it when it comes to Judge Jackson's record. They understand that she is immensely qualified, and so there is no there to their attacks, and they have to resort to other things like bring up previous hearings and confirmation processes. And so one thing I want to mention about Lindsey Graham, though, is that while this might be an opportunity for political theater, it really shouldn't be. And the I guess the disturbing part about all of it is that if he wanted to stand up and give a speech about Judge Jackson, then there are plenty of avenues to do that. This hearing is to vet and to ask questions of a nominee for the highest court of the land. It's an extremely serious platform right now. And instead, Senator Lindsey Graham just made a fool out of himself. And it is really, really troubling to see the politicization from Republicans. Instead of really trying to dig through some of the issues, they're trying to really go at it and attack her when she has pushed back, rightfully so, because as Ted Cruz said, there is no there there.
And do you not think that Democrats also use this as an opportunity to be in the spotlight and to grandstand?
Well, I think that, and I should correct myself, it was Mitt Romney who said there was no there there. And I think that Democrats are using this as an opportunity to show that she is extremely qualified. She would be the most qualified person, or is the most qualified person to be nominated to the Supreme Court. That's what the senators are trying to do. They're pushing back when they need to, where you have seen from the chairman and other senators. And they're also trying to highlight her record and how she has been confirmed before, how many members of the panel have confirmed her, have both Republicans and Democrats. And so they are trying to show her independence, her strong record, and really the substance behind Judge Jackson.
Antonia, what do you think Judge Jackson needs to do to get Republican support from any of the Republicans? Is it a possibility?
I think there are a couple. I would also just note that she doesn't have much of a record. She acknowledges that. She's been on the appeals court, the D.C. Circuit, for less than a year, so she doesn't have much of a record. She also doesn't have much of a judicial philosophy. She was a trial judge. She is not the most qualified person. She is very qualified, but there were a lot of nominees that the president had at his disposal. She has got a very interesting and incredible career trajectory, but in terms of judicial thought and in terms of sort of paving the way in terms of interesting legal discussions and constitutional questions. There's a reason the president of the United States chose her. She does not have a record. Administrations do that. And that's wonderful for her. I expect that she's going to be confirmed to the Supreme Court. She's an incredible life story. She's incredibly smart, incredibly poised, and has done well. But I want to be very clear here. She is going to be, my fear, she is going to be a liberal justice that does not show independence. I hope I'm wrong. She said a lot of incredibly interesting things that make her sound like Justice Scalia, God rest his soul. I hope she is independent. I hope she has interesting lines of thought and inquiry. Right now, I don't hold my hopes up. I think you're going to see some Republicans support her. I would fully expect Susan Collins to do that. She's going to wait till the process is done. Susan Collins has always voted for every Supreme Court nominee she has had before her, Republican or Democratic administration. I'm not so sure about Senator Murkowski. Senator Romney, we'll see, but I would expect she's going to be confirmed, and with at least one Republican vote would be my guess.
Now, Sochi, she doesn't need Republican support. Assuming she has all the Democrats on board, that's really all she needs, plus a tiebreaker from the vice president. So does it matter if she gets any Republican support?
Well, that's right. She doesn't need Republican support. But I think that the goal from this White House, and it was from the start when they picked former Senator Doug Jones to really lead her through this process. He's someone who is loved by both sides in the Senate and is someone who understands the Senate. And the entire process has been pretty transparent. And the White House's hope is that she does receive some bipartisan support, because she has received bipartisan support throughout her career. Just last year, members of both the Republican Party and the Democratic Party voted to confirm her. And so the hope is that, yes, there is some bipartisan support around this. I think when we're looking at what we do in Washington and what we try to accomplish, it's very rare to find that support from both sides of the aisle. But I think this is one, given her experience, where you will see a few members of the Senate on the Republican side come over and vote for her.
And Antonia, we have heard several people say that she sounds Scalia-esque at times when she is talking about her judicial philosophy. She's talked a lot about regarding the text text, going back to the text, the original intent of the text. Do you think that might help get some Republicans on board?
No, I do not. I think this has been a long learning in terms of Supreme Court fights. This is learned after Judge Bork was defeated in the Senate, and that started with Justice Ginsburg and has kept on going all the way through. The judges appointed by or nominated by Democratic presidents have been very consistent in trying to emulate what we're seeing today by Judge Jackson. And I would note that it was, I believe, Elena Kagan who said, we're all originalists now. That's what she said over 10 years ago when she was nominated and confirmed by the Senate to the Supreme Court. This is kabuki theater and performance art. I understand it. They don't want to say anything that could prejudge any cases. I understand that, but we have to understand this is part of the dance. I do not think that what she is saying here today, as well done as she is doing, I do not think it's going to reflect what she will do if and when she is confirmed to the Supreme Court.
All right, Antona Ferrier, Xochitl Hinojosa, thank you both.
Take care.
And Judge Jackson's background as a public defender has been a focal point of some of the questions she's faced, especially when it comes to how her experience defending criminals may impact her decisions in the highest court in the land. Alicia Bannon is the director of the Judiciary Program at the Brennan Center for Justice, where her work focuses on promoting a fair judicial system in an inclusive democracy. So, Alicia, thanks for being here. Why do you think Jackson's experience as a public defender has become such a focal point for Democrats trying to showcase it as a positive and Republicans trying to argue that that perspective makes her soft on crime? How would this impact her decisions as a Supreme Court justice?
Well, it's a perspective that has been completely unrepresented on the bench on the Supreme Court. There has never been a public defender ever to sit on the U.S. Supreme Court. And the last justice that had any substantial experience representing poor criminal defendants in our justice system was Thurgood Marshall, who retired from the Supreme Court more than 30 years ago. So it's a really important perspective to have somebody that's had to navigate the criminal justice system representing criminal defendants, having that perspective in the room. The Supreme Court gets thousands of petitions in criminal cases every year, and having somebody who has had to think about and lived, what does it mean to have adequate representation by your lawyer? What does it mean to have a fair trial? What does it mean for somebody to really understand the charges against them and all the other kinds of issues that come up, sentencing, to have somebody that's experienced that on the side of representing poor defendants is a really critical perspective. And I think that's why so many people were so excited about her nomination, because that is not a perspective that has really ever been represented, or at least in recent years, on the U.S. Supreme Court. Of course, because by very nature, defenders don't get to choose their clients. And sometimes their clients are very unpopular people. And so I think part of what we have been seeing right now is, unfortunately, an effort to sometimes conflate her appropriate zealous advocacy, her doing her job, and a requirement of the Constitution that you give a defendant as strong a defense as possible, trying to conflate that with her own, her own views on the rule of law, trying to kind of discredit her when actually having that kind of experience is a tremendous boon to the court and to the development of the law.
Now, Judge Jackson has avoided sharing her personal and sometimes professional view on a lot of questions, as do many Supreme Court justice nominees. So what do you make of the choices so far, and what questions she answers in detail, and where she's choosing to be more vague or evasive?
Well, I think that we are seeing I was very impressed with the detail in which she talked through how she thinks about sentencing. She is a judge. Another thing that distinguishes her, there's only one other justice on the Supreme Court right now, Justice Sotomayor, that has trial court experience. And, I think we're really seeing how that experience has sort of shaped both her judicial philosophy and, her approach to tricky legal questions. So I think she spent a lot of time walking through how she thinks about sentencing, what are the steps, how fact dependent it is, what are the different considerations. I think she's taken this as an opportunity to really talk about the experience that she brings to bear. I think on some of the places where she hasn't gone into detail, it's a very normal thing. We see this in every confirmation hearing where they'll be probing on questions that are likely to be coming before the court or maybe pending before the court right now. So, for example, the court right now is hearing a case about the scope of abortion rights in this country, where we may very well see Roe v. Wade overturned or dramatically curtailed. She would not, and it would not be appropriate for her to be discussing in great detail how she's thinking about legal issues that are active and are even being considered right now before the court.
And there's also been a lot of accusations on both sides about the integrity of the court and the money and special interest behind Supreme Court nominations. How important is the integrity of the court, and where does it stand right now?
Look, public confidence in the judiciary is a critical value. Courts, they don't have the power of the purse. They don't have armies. What they have are the people's public trust and willingness to abide by the decisions that the court makes. And so having public confidence in the judiciary is really critical. By a lot of measures, that public confidence is declining. There was a recent survey showing very few Americans think that the court is making decisions without thinking about political considerations. The approval rating of the court has really been dropping. And, I think there's a lot of reasons for that. But one of the elephant in the room, or one of the elephants in the room in this confirmation hearing, has been that, we're operating in the backdrop of a really radicalized, 6-3 conservative majority on the U.S. Supreme Court right now. And I think as we're seeing the court, potentially rolling back well-established rights, I think that is being very aggressive in the use of the shadow docket and other kinds of emergency measures. That's making people worried about, is the court playing the role that it's supposed to be playing? And I think Judge Jackson very compellingly, spoke about what the role of a judge is and how she thinks, what her judicial philosophy is, how she thinks about the law, and how important it is for judges to be fair and impartial. She also spoke about public confidence in the court from the perspective of diversity on the bench. I thought that was one of her most compelling comments thus far, just really talking about how important it is for communities who are affected, in tremendous ways by the decisions that courts make to see themselves reflected in the bench so that they can be confident that the court is making decisions in a way that, understands the people that are being affected by them.
All right, Alicia, we appreciate your time today. Thank you.
Thank you.
We'll be right back.
The most powerful stories of our time, anytime. Nightline. Now streaming on ABC News Live 2020. True crime, cinematic, real-life drama, stunning, the unthinkable. Follow the clues, the hunt. True crime 2020. Now streaming on ABC News Live.
National parks are incredibly safe places, but crime will happen.
My wife had fallen. She's in really critical condition.
At that time, I thought it was just a tragic accident. There's still a lot of questions we need to ask.
There were small things that didn't totally add up.
This is 2 lives for Harold that have died now. I was shocked. Something's not right.
I know what happened, and I'm not guilty.
Why the fascination with criminal trials? Figure out what's really out there.
She revealed she had murdered his family.
I know in my heart they did this.
It's the time of suspicion.
The ending's really tough.
You don't know whether truth is going to be difficult to find unless you try to find it.
America's #1 news, ABC News. Most watched, most trusted, and streaming live to you anytime, anywhere, and free. This is ABC News Live, America's #1 streaming news. Free to you 24/7. Watch America's #1 news whenever you want it, wherever you are, anytime. ABC News Live, streaming live and free on all platforms.
Michael Severin survived 5 tours of duty, but he did not survive 5 months of marriage to Wendy Davidson.
When you do interviews like this, you always wonder what it's going to be like looking into the eyes of a killer. But Wendy doesn't look or act like any of the killers I've talked to. Why did you decide to do this first network interview?
The new 2020.
Then the bombshell. Turns out that dead men do tell tales.
Premieres Friday night on ABC.
I want to help people, and I want to be a billionaire. I'm on the cutting edge of healthcare. This machine tests your blood in your own home.
You're in over your head. You're going to lose everything.
You don't understand the science! Her whole image is fake.
I don't believe a word she says. You don't understand the vision.
Never met anyone quite like you, Miss Holmes.
There's not.
Is that the gun?
That's not a gun.
What is it? I won't ask you again then. Are you a Nazi?
The deeper you go into the black market,
You could be putting your life at risk.
the darker it gets.
Why hasn't anyone come out and spoken?
It's about the money. That's all we do.
Trafficked. New episodes Wednesdays at 9 on National Geographic.
These days, with so much going on, it's hard to keep up.
While others are recapping yesterday's headlines,
We're bringing you the right now.
This is the busy border crossing. Steel barricades, another strike.
The Right Now look at the day ahead, how it affects you and your family.
Record high gas prices.
The threat of cyber warfare.
Is peace possible?
World News Now beginning at 2 a.m. Eastern, followed by America This Morning.
America's #1 early morning news.
Streaming here on ABC News Live.
It was an extraordinary story.
A computer salesman was supposed to report to prison to begin a 17-year sentence.
They let him turn himself into jail with no escort.
No one thought he would run.
How do you evade capture for 25 years? How do you do that?
Now, join the search, following the U.S. Marshals as they uncover new leads in a global manhunt. Can you help catch this fugitive?
Have you seen this man?
Have you seen this man?
Have you seen this man? Listen and join the all-new hunt wherever you get your podcasts.
Welcome back to our special coverage of the Supreme Court confirmation hearings for Judge Ketanji Brown Jackson. Senators are set to resume questioning Judge Jackson any minute now. Let's bring in senior Washington reporter Devin Dwyer, who's there in the committee room, politics reporter Brittany Shepard, and ABC News Supreme Court contributor Kate Shaw for more on all of this. Devin, I'll start with you. As the senators start coming back in, we're going to see some more questioning again from some of the younger senators here. What do you expect to hear?
Well, first we should say, Diane, there's something developing right now. The committee was supposed to convene about 15 minutes ago. They were taking a 30-minute lunch break. And as you can see behind me from the live picture, they have not come back into the chamber. We did see a few senators start to trickle in. Josh Hawley, Ted Cruz, who are next up, brought in a pile of materials. In fact, you may be able to see over my shoulder, the easel is back for Ted Cruz, so perhaps some more poster boards for his display. But they were all hurried out of the room to a meeting in the back hallway here. Our team, Trish Turner, our reporter behind the scenes, is trying to figure out what exactly is going on. Perhaps this is over that controversy over documents that Republicans had created somewhat of a stir about. Maybe there's something else going on. But stay tuned, because this hearing, which still had 4 to 5 hours left to go today, has come to a standstill here in the Senate. So we're watching this closely. Ketanji Brown Jackson's parents are back. You see them in the front row on the left side of your screen there. They've been taking pictures and selfies, and that gaggle of camera people waiting for the judge. She's still being held in her waiting chamber, but again, right now, and I am just seeing some of the senators come back, so it looks like they have broken, and we could be close to starting. Ted Cruz will be next up, Diane.
Brittany, Ted Cruz, just one of several members who do try to score political points here, particularly with an election coming up. So what are you looking out for as the questioning continues now for the rest of the day?
looking for as many hits on culture war issues as possible. I think Republicans know what they have on their side is legal ignorance from voters and from many watchers. I mean, even for us, the most keyed-in people, we're learning more about law as the minutes drone on here. And so for the average American who's tuning in, they're not going to know one statute from the next, but they are going to know the term critical race theory. They are going to be worried about crime. They are going to be worried about putting folks behind bars. They are going to be worried about child pornography, even if the nuance, especially if the nuance is lost on them. And when those questions are clipped, and when Ketanji Brown Jackson knows that she cannot answer those questions, in fact, because many of them are political answers, you can look at the answers she gives when she's asked about packing the court. She says, I understand it's a political question, and that's precisely why I'm uncomfortable speaking on it. You know, it's legally sound and it's fair, but to the unread-in viewer, they're going to think that she's dodging. That's what Mitch McConnell is hoping for, telling reporters in the hallways that Ketanji Brown Jackson is being evasive. And Republicans know they have that on their side. So they are likely going to ask as many political questions as possible, where they're going to get no answers, short answers, or please, I'd like to move on sort of answers. And Democrats are going to have to hope that those same viewers are tuning in longer to see their humanizing closing arguments, bringing in Ketanji Brown Jackson's family, her brother, her uncle, her daughter, who is sitting behind her today, and hope that they'll kind of read through the weeds a little bit and stick with them on closing arguments. But it's going to be, I would say, a political dunk fest full of props. You see, I think I saw an easel behind Devin, behind his left shoulder. And so I think we're going to see a lot of hits on culture war, on politics, anything that can really drum fear in the hearts of voters, especially those who are undecided coming the midterms, and of course come 2024 in just a few years.
And Kate, there is certainly a category of question that falls squarely in the line of politics where you know before the question's even asked that no Supreme Court nominee would ask that. And then there are other questions that kind of go either way, and some Supreme Court nominees might choose to give more information than others. And we've seen Ketanji Brown Jackson at times offer real specific answers, a lot of details. She'll go into details about a particular case that pertains to the question and so on and so forth, and others where she chooses to be much more vague, maybe even evasive. What do you make of her choices so far?
I think she's very willing to be quite detailed when describing her own judicial process, cases that she has decided, even those where she was reversed by the D.C. Circuit, because there have been a few she's been pressed on. But anything outside of that, abstract, sort of hypothetical questions, things that might come before the court that are pending right now before the court, I would say I'm not sure she's being evasive. She is definitely being circumspect. But you know what? There's a very well-established tradition of declining to answer those kinds of questions. Think about President Trump's third nominee to the Supreme Court, Amy Coney Barrett, just about a year and a half ago. Answered virtually no hypothetical or abstract questions, wouldn't opine on even clearly settled law. You know, that's essentially how these hearings proceed. So if she does decide to, you know, stay pretty quiet on some of these questions, she's going to be working within a well-established tradition that is quite bipartisan at this point.
Well, and so given how long that tradition has been at play, is there any chance that changes anytime soon, where we do start seeing justices answer these questions, or justice hopefuls anyway, answer some of these questions?
I had thought that might be the case here because, of course, this is the first Democratic nominee in the post-filibuster era, right? So she actually doesn't need, as we've talked about earlier, she doesn't need to get any Republican votes. So, you know, you might imagine that this is an opportunity to be a little bit more forthcoming, to educate the American public about the judicial process, the role of the Supreme Court, even specific legal questions. But it doesn't look as though that's likely to happen. She's likely to remain pretty quiet on some of these, you know, hot-button issues.
Kate, thank you. We do have some breaking news to report now. We're now hearing that former Secretary of State Madeleine Albright has died. I want to go to Jonathan Karl on the phone with some of the details here. John, what do we know so far?
Well, we know that she died of cancer, surrounded by her family. Of course, as soon as I heard the news, it occurred to me that in short order, we have lost two iconic Secretaries of State, Colin Powell and Madeleine Albright, in very short order. Madeleine Albright, of course, the first woman ever to be Secretary of State, somebody who was the U.S. ambassador to the United Nations in the first term of President Bill Clinton, and then the Secretary of State for nearly the entirety of the second term. And what's interesting to me here, as I think back on her legacy, is that just a month ago, she wrote an op-ed in the New York Times calling Vladimir Putin's invasion of Ukraine an historic mistake. And in that op-ed, she reminded us that she was the first senior U.S. official to meet with Vladimir Putin in his capacity as the president of Russia. This was back in 2009 after he had taken over for Boris Yeltsin. And she recalled not knowing what to make of him, knowing he was a former KGB spy, but having a bit of a chill in meeting him and a sense of foreboding. Madeleine Albright, in her time as Secretary of State, was a strong advocate and helped make happen the initial expansion of NATO that we saw after the end of the Cold War. And she was the Secretary of State that pushed for intervention, U.S. intervention to stop a genocide in the Balkans, in the former Yugoslavia. So she, 84 years old, has just died. There'll be lots of talk about her legacy. But when you look at the issues that we're dealing with right now with Ukraine, she, was somebody who was very much aware of what was happening, had strong opinions about what was happening right up until this invasion, and knew very well the history and the fears that the world she felt should have about Vladimir Putin.
And John, she herself was a native of Prague. She came to the United States as a refugee herself in 1948. What does that do for the color that she added to this conversation just before her death?
I mean, think of it. She was a refugee from war-torn Czechoslovakia, and escaped the ruins of World War II to come to the United States. She later learned, she didn't know at the time. She actually didn't know until she became Secretary of State that her parents were Jewish and had fled the Holocaust. So I think that looking at this, and you see this in this op-ed, it's really worth going back to read. She just published a month ago talking about Putin's decision to invade Ukraine. I think that she saw echoes of what she had fled as a very young child in the aftermath of World War II.
And John, she also received the Presidential Medal of Freedom in 2012, America's highest civilian honor for her service to this country. What is her legacy?
Well, her legacy, the first line will always be the first woman to be Secretary of State. She was a fervent advocate of the United States, what she called aggressive multilateralism, becoming a force for good in the world, but not doing it as an arrogant, go-it-alone superpower, but working with our allies. And a big part of that was pushing for democratization in the very region that we are now watching war unfold in Eastern Europe. As an Eastern European of Eastern European descent herself, she felt it was very important to see, communism was gone. Now it was important that Eastern Europe be welcomed into the West, into Europe, into the Western Alliance, become democratic, and enjoy the prosperity that Western Europe had after the Iron Curtain, descended across the middle of Europe after World War II. I think that'll be a big part of her legacy. The other thing is she was a feminist icon. She had something she said quite frequently. She would say there's a special place in hell for women who don't help other women. And she was a early and aggressive advocate for Hillary Clinton when Hillary Clinton ran for president both times, actually. And somebody, she was certainly a partisan Democrat, but beyond that, she was a strong advocate of women and women's rights for the entirety of her career.
All right, Jonathan Karl, ABC News Chief Washington Correspondent. I almost called you correspondent again. Sorry, Jonathan, our Chief Washington Correspondent. Thank you. And again, that breaking news, the country's first woman Secretary of State, Madeleine Albright, who served under President Bill Clinton, has died. Her family says she passed away of cancer. Madeleine Albright was 84 years old. We'll be right back.
And it has to be an actual dispute, that federal courts cannot simply issue advisory opinions on a question they may have a view on. And one component of Article 3 jurisdiction is the requirement of standing, that in order for a plaintiff to have standing to bring a case, that plaintiff, at least generally speaking, must have a real and concrete injury. Is that right?
That is correct.
So, for example, that means that even if I might have a disagreement with some particular policy or some particular law, that I can't bring a case unless I am personally aggrieved by that policy or that law. So, for example, you're in my alma mater, Harvard, is currently being sued for its explicit and, in my view, egregious policy of discriminating against Asian Americans. Even though I think that policy is egregious, I, as an individual plaintiff, could not bring a lawsuit challenging it because I am not Asian American. Is that right?
If you brought a lawsuit, the court would have to evaluate whether you had an actual injury in order to be able to determine whether it had subject matter jurisdiction to hear the suit.
But if I'm not in the class being discriminated against, then I don't have the ability to bring the lawsuit. Is that right?
I think you'd have to have an actual injury. Certainly people, I think, who are in the class could claim that they had an injury for that purpose.
So now you're on the Board of Overseers of Harvard. If you're confirmed, do you intend to recuse from this lawsuit?
That is my plan, Senator.
Okay. We discussed yesterday how the standard for race discrimination was strict scrutiny. The court has laid out a different standard for gender discrimination. What is the constitutional standard that applies to gender discrimination?
Gender discrimination, the court has held intermediate scrutiny applies, which is that the government has to have an important interest, and the tailoring doesn't have to be as narrow.
Right. So yesterday, under questioning from Senator Blackburn, you told her that you couldn't define what a woman is, that you were not a biologist, which I think you're the only Supreme Court nominee in history who's been unable to answer the question, what is a woman? Let me ask you, as a judge, how would you determine if a plaintiff had Article 3 standing to challenge a gender-based rule, regulation, policy, without being able to determine what a woman was?
So, Senator, I know that I'm a woman. I know that Senator Blackburn is a woman, and the woman who I admire most in the world is in the room today, my mother. It sounded as though the question was...
But let me ask, under the modern leftist sensibilities, if I decide right now that I'm a woman, then apparently I'm a woman. Does that mean that I would have Article 3 standing to challenge a gender-based restriction?
Senator, to the extent that you are asking me about who has the ability to bring lawsuits based on gender, those kinds of issues are working their way through the courts, and I'm not able to comment on them.
Okay, if I can change my gender, if I can be a woman, and then an hour later, if I decide I'm not a woman anymore, I guess I would lose Article 3 standing. Tell me, does that same principle apply to other protected characteristics? For example, I'm an Hispanic man. Could I decide I was an Asian man? Would I have the ability to be an Asian man and challenge Harvard's discrimination because I made that decision?
Senator, I'm not able to answer your question. You're asking me about hypotheticals and
I'm asking you how you would assess standing if I came in and said, I have decided I identify as an Asian man.
I would assess standing the way I assess other legal issues, which is to listen to the arguments made by the parties, consider the relevant precedents, and the constitutional principles involved, and make a determination.
Okay, let's go back to your favorite topic of this hearing, which is the criminal law cases you had as a district judge, and in particular the cases involving child pornography. Now, your defenders, both on the Democratic side of the dais and also in the press, have suggested that the criticism that has been raised has been somehow cherry-picked, that it's only some specific examples. So I'm going to give you an opportunity to discuss each and every case you've had, because looking at your cases, and I've now examined all of the child porn cases you've had as a federal district judge, there is a very consistent pattern. So let's start, and by the way, I'm excluding the cases. So Senator Durbin and Senator Coons focused on the Nickerson case, the Fife case, the Nguyen case, and the Hilly case. I'm excluding those because those are not child porn cases. Those are actual sexual assault of a child, which is markedly different. And I will concede when you're dealing with sexual assault, you have been willing to impose stricter penalties. So let's focus on actual child pornography cases. And let's go through each of them, because if it's right that we're cherry picking, then you should be able to explain quite powerfully. Now, your justification is that you're following the statute. And as you know, 18 U.S.C. section 3553 lays out the factors that as a district judge you had to consider in sentencing. And let's start with the Hess case, United States versus Hess. Now, in that case, a man sent 6 pictures of a prepubescent girl that he claimed was his daughter to an undercover law enforcement officer. Officers found over 600 images of child pornography, including images of sexual acts being performed on prepubescent children. The defendant pled guilty, and I believe in all of these cases the defendant pled guilty. So there's no question about guilt. They came in and pled guilty in your courtroom. The charge carried a mandatory minimum sentence of 5 years and a mandatory maximum sentence of 20 years. The sentencing guidelines recommended 151 to 188 months sentence. The government, as part of a plea deal, agreed to argue for 60 months, but didn't agree that that would be the sentence, simply that they would advocate it. And you, in turn, sentenced Hess to 60 months. So under the terms of the statute, why did you choose to sentence Hess to the absolute lowest possible sentence you were allowed to sentence under law?
Thank you, Senator. I have spoken at length throughout this hearing about these cases. I've said what I'm going to say, which is I've taken every case seriously. These are very horrible
I'm asking you specifically
crimes,
about the Hess case.
I've taken every case seriously.
So you're not going to answer that?
These are very horrible crimes, as was that one. And as a mother, having to look at these pictures, having to follow Congress's directive, having to listen to recommendations like the government in that case, which argued for 60 months, I imposed the sentence that I believed was the sentence that was required by law.
So I believe you, and I've read your sentencing hearing in each one of these cases for which we have transcripts, and there are several of which we don't have transcripts. So in each of these cases, you read from the same script. So in each of these cases, you say that the distribution of child pornography is an extremely serious federal crime. And you point out that the crime involves people who are taking pictures and videos of real children while the children are being sexually abused. In Hess, you pointed out that he had hundreds of images of children in sexually compromised position.